Oh, I don't have a thing. Okay. I'd like to call this meeting to order, the April 3rd Sunshine Ordinance Task Force meeting. Madam Clerk, will you do roll call?
Yes. Member Nee?
Here.
Nee here. Monet?
Here.
Monet present. Washburn?
Here.
Washburn present. Pilpel?
Present.
Pilpel present. Sims? Sims absent. David? David absent. Highland?
Here.
Highland present. Oka?
Present.
Oka present. Fisher?
Present.
Fisher present. Chair Grant?
Present?
Present. Madam Chair, you have a quorum.
Great, thank you. Member Sims is running late. He will be here in about 10 minutes. And Member David is absent. He is traveling and let us know that yesterday. Let's go to any agenda changes. First of all, file item number 12041, file number 12042, the complainant requested that we postpone these two cases until further notice. I'd like to see if I can get a motion to have this continued.
I actually need to make a disclosure first on the underlying complaints. I need to make a 3.214 disclosure that I have a personal friendship relationship with the respondent, and at this time I don't feel that I need to request recusal, but I did need to state on the record under 3.214 that I.
Is this
I know
on
the person.
12041 and 12042?
Yes, it's Ms. Areola. And I'll
okay.
repeat that disclosure
Great.
when the complainant is present, and we can deal with it then if we need to. But I needed to make that disclosure, and then we can move on with the scheduling issue.
Okay, great, thank you. And the respondent is okay with postponing that. So since you want to postpone until further notice, I wanted to call to not necessarily do it for the next meeting, but to call the chair. So do I have a motion to continue this?
So moved.
Great. It's been moved and seconded that we will postpone the file number 12041 and file number 12042 to my call next meeting.
Take public comment and then
Public comment?
if there's any.
Okay. I'd like to open up for public comment on postponing those two items. If there's no public comment, we'll move on. Madam Clerk, will you go to the next item?
And we'll do that without objection.
Yes. It's been moved and seconded without objection. Madam Clerk? I'm sorry. Are there any more? Does anyone have any agenda items they'd like to discuss or changes or anything? No? Okay. Madam Clerk?
Okay. We'll move on to item number 5 then. So that's file number 12048, complaint filed by David Schneider against Municipal Transportation Agency for allegedly denying fair and uniform speaking time for public comment.
Public comment number 4 is at 5 p.m. That's general public comment on things that aren't here. Because the items 2 and 3 were asked to be postponed. Great.
We'll see you in 40 minutes.
Madam Clerk, where were you? Oh, item number 5. Did you finish? Oh, okay, I'm sorry. The jurisdiction issue has been, let me pull it up. I don't believe that has been accepted by both parties. So I'd like to call for a motion and a second to accept jurisdiction.
So moved.
Second.
It's been moved and seconded, and the motion passes without objection.
Public comment?
Is there any public comment about jurisdiction? No? Okay. Then I'd like to invite the, what?
Just one quick comment.
Yes.
There was a disclosure note here that the complainant knows me, but we're not
Yes.
close personal friends, and we're so not close personal friends that he misspelled my name. So,
Okay.
But I won't hold that.
Great.
Yeah.
Okay. I'd like to invite David Schneider up, and you have 5 minutes in which to tell us about your case.
Thank you.
Microphone, please.
Thank you, commissioners.
Is it on?
Yes, ma'am.
You can.
Is this on?
There it is.
It's on now.
We're on now.
Thank you.
Okay, well, maybe a little bit too on. My name is David Schneider. I'm a longtime cab driver in San Francisco, and have attended a number of SFMTA meetings. And for purposes of identification, I'm co-founder of United Taxi Cab Workers. And although the particular issue of the October 16th meeting about which I'm concerned didn't necessarily go to the core of traditional employee rights, it did affect the working poor. And there was a question about, drivers were told, and I think Mr. Toronto will speak to that later. He can connect the chain of circumstances. They were told to be there, but then apparently the SFMTA changed its mind. One of the matters that was coming up was the status of the waiting list. It's one of the few benefits a driver can have, and apparently they were given only 1 minute of time to each speaker. Each cab driver was given only 1 minute of time, whereas earlier in the meeting, others that showed up, say for the felon Divisadero bicycle lanes, were given 2 minutes. And the question is whether or not that was fair and consistent with both the spirit of the Brown Act and the equal protection of the laws under the 14th Amendment. I do believe, and I could be wrong, that when you commissioners take your oaths of office, you also take an oath of office to uphold the Constitution of the United States. It seems to me that it's inherent in the discharge of your duties that you also want to carry out the spirit of the equal protection of the laws so that the great, pardon my editorializing, the great unwashed can get their point of view across to the SFMTA and not have the rules of the game changed right in the middle of the game, not knowing when they can speak, which meeting they can come to. If this had only been one instance, perhaps it's okay. We all make mistakes, but it seems to be a pattern there. And although my own particular interests were not affected, the rest of the many cab drivers' interests were affected by reducing their time to speak. Chairman Nolan, in fact, his exact words, according to the complaint I filed, at 3 hours and 8 minutes and 45 seconds into the SFG TV video, which I believe is the true record in this case, said the following: considering the hour, and we also have a major issue coming up in our closed session, we are going to limit public comment to 1 minute. But that was 3 hours into that. Prior to that, the public got 2 minutes. And particularly for people, many of the working poor cab drivers whose English, whose primary language may not be English as a first language, they don't understand all the nuances of changing procedure in the middle of the game and all of that. So I think I've said enough. The matter is before you on the basis of the complaint I filed. If any of you would wish hard-bound the old-fashioned paper copy of the complaint rather than the electronic version, I made about 15 or 20. And also, David, I'm sorry I misspelled your name. I won't do it more than 3 or 4 or 5, 6 times in a row. There is one other matter that I want to raise too. I think that Commissioner Oak should consider, in view of his prior closeness with the SFMTA, whether or not he can render a fair and impartial judgment in this matter. He might want to consider recusing himself, but I'll leave that up to him. Would any of you like hard copies? Okay.
No, thank you.
Thank you very much. I think Mr. Toronto will speak to some other matters as to the chain of how drivers were told one thing and when to show up, and then all of a sudden it changed in the middle of the game. Thank you.
Thank you. Do you have so Mr. Toronto, I think that's your name? So we want to speak to the issue at hand, to this particular case?
Yes.
Okay, great. Oh,
Yes, my name is
Did you want to
Barry
say something?
Toronto, and I was actually be the one to file this complaint, but I couldn't do it I immediately, and he did it for me. So it was basically our co-complaint in some respects. However, I want to say, one, there was a town hall meeting on October 9th. At that meeting, cab drivers and cab managers and other industry people were told to show up on October 16th. At that time, Chris Hayashi, the director of taxi and acceptable services for the MTA, was still on leave, and communication between the industry and the MTA was still very poor. I went back and looked at my emails. I keep all my emails related to taxis. And there was an email Friday night from somebody associated with the industry saying, it looks like we're not going to have that item on the agenda. But it was the start of the weekend. And who's going to find out about this stuff in time for Tuesday? And, you know, cab drivers, not all of them they work many hours. They don't always have the time to find out about these things. And so a lot of them showed up expecting to speak. So then they switched the agenda item of public comment number 9 with number 11, which was about the Fell Oak Street bike lanes. And during the executive director's comments early in the meeting, he did say that there was no taxi item on the agenda, but that time was too late. Everybody was already there to speak. So then 3 hours into the meeting, which is after 4 o'clock, a lot of the people who wanted to speak had left. Most of them had left because they have to go change their shifts, turn their cabs in, go get their cabs, go get their kids from school, and so the problem is that people who did stay were only given 1 minute, and a lot of them didn't speak English very well, as you heard from Mr. Snyder. And so all of a sudden to get 1 minute was totally arbitrary and capricious, and it was done for a reason because he was tired, basically. He didn't say it in so many words, but he had other pressing issues. Now, compare that to earlier in the year when they had the free Muni for youth, and they had a lot of non-English speakers, and they had a lot of translators show up, and they spoke during public comment as well. So my concern is the issue of treating one topic more important than another topic. Now, sometimes I switch agenda items because there are more people there to speak to another item. There was no poll done to see whether at the beginning of the meeting there were more bicycle advocates there than there were taxi drivers interested in speaking about an important topic. The topic was about the waiting list. They hadn't had a taxi topic since August 21st, and there was nothing in September. There was no October 2nd meeting. So the next time they could really speak on a taxi issue, which they could, was October 16th. And then they were told, well, that at the meeting they were not dealing with any taxi issue until November 20th. Thank you.
thank you very much.
Totally ludicrous.
Is there anyone else here to support Mr. Schneider's, introduce facts and evidence in support of Mr. Schneider? No? In that case, I'd like to invite the representative from the MTA up. And you too will have 5 minutes.
Thank you. My name's Roberta Boomer. I'm the Board Secretary for the Municipal Transportation Agency. Thank you for your time today. The board is very aware of this issue with regard to drivers told to attend a meeting and then the item isn't on the agenda. And they are concerned about it. It has happened several times. However, and staff is working to make sure that that does not happen in the future because it does cause disruption. However, that is not within the jurisdiction of the MTA board and it is not covered by the Sunshine Ordinance. Hopefully, we're going to address that. So the agenda was posted on Friday. Many members of the taxi industry do receive the agenda electronically. It's posted online at the library, outside of the meeting room, at our headquarters. Copies are brought to the room, and the director did announce that there were no taxi items. So it was the information that no taxi items were on the agenda was available well in advance of the meeting. But that's really not the issue before you all today. The issue is with regard to the time limits. It is in the jurisdiction of the chairman to set a time limit of less than 3 minutes for for items on the agenda. It is indeed true that the chairman did set a time limit of 2 minutes for item 11, which was uniformly enforced for all of item 11. Later on in the meeting, when he got to general public comment for matters that are not on the agenda, he set a 1-minute time limit, and that was uniformly applied to all members wishing to speak during that. The question of whether or not the MTA violated the public meeting laws by failing to provide members of the public the same amount of time to comment for each item on the agenda, clearly, the film is there, and it's easily proven that the same amount of time was provided. I have nothing more to add, and I'm happy to answer any of your questions.
Thank you. Is there anyone here to support any of your statements? The same more facts and evidence? Okay, great. In that case, I would like to open it up to members of the board. Mr. Oka?
I would like to address the point made by Mr. Snyder.
Is there any rebuttal? Any rebuttal?
There will be.
There will be.
Hang on. I do know Mr. Snyder and Mr. Toronto, and I have always been able to render decisions impartially, and I think the record of me being able to do that speaks for itself. It is well documented that I have never, ever let my association with anybody affect the way I vote. So if I don't think I have to recuse myself. If the city attorney feels otherwise, I will adhere to that decision. Mr.
City Attorney 3.
Through the chair to member Oka, a decision on this type of conflict is largely up to the member. It's whether you think you can render an impartial decision given the relationships you have.
Okay.
And you believe that you can render an impartial
Yes.
decision? Okay.
Yes.
Thank you very much for that. So we will move forward, and Member Oka will hear and vote on this particular case before us. Member Pilpel.
Yes, I have several things to say about this. I was at the subject meeting. It was, at this point in the agenda, I would say a fairly heated and contentious matter. There were a number of members of the, let's just call it the taxi community present, who were displeased that there was no taxi item on the agenda and that they had been made to wait, and finally that public comment, that general public comment was reduced to 1 minute. The sensing that a complaint might emanate and not wanting to take a position at that time, I chose my words carefully in public comment, which was summarized at that point as saying that I discussed the level of rhetoric and that comment should be professional and not personal, which I think is a fair characterization of my comments. The minutes of the subject board meeting, which I pulled down today on the website, which, by the way, Ms. Boomer, don't have a cover page. They just start with the order of business. Don't reflect they do reflect that Chair Nolan asked that item 11 be called after the director's report. They don't reflect that the consent calendar was also taken prior to public comment. So in substance, I believe that actually what both sides said was true, that there were members of the taxi community who waited and felt that that was not okay, and they were fairly heated in some of their comments. It's also true that a uniform time limit was applied as to each agenda item, and, you know, again, that was true. Where I'm going with this, and I would refer members to section 67.15C, which is on page 27 of the packet and is pretty available in the binder elsewhere. A policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting the total amount of time allocated for public testimony on particular issues and for each individual speaker, et cetera, et cetera. For me, the question is whether the regulations adopted at that meeting for that item were reasonable under the circumstances, which for me is under the totality of the circumstances. And so that goes to a broader question of whether, and I'm not sure that it's a 14th Amendment issue, but a broader question of whether at the time those members of the public, taxi community or others, reasonably believed that their item or the general public comment in the absence of a taxi-specific item would come up either in the order of the agenda or be noticed during the meeting that they would have an opportunity to speak and that they would have a reasonable opportunity to speak, as had others, particularly given the number of people there and the time that they had waited, whether or not this other relatively controversial Oakville bike issue was on the agenda. I also want to note, notwithstanding the assertion that there was a complicated and difficult matter in closed session, the minutes accurately reflect that the closed session began at 4:57 and was adjourned at 5:05. So a closed session of only 8 minutes for a complicated matter. Regardless, again, I would go back to the question of the totality of the circumstances and whether the imposition of a 1-minute time limit at that time was reasonable. And I am leaning to believe that it was not reasonable under those circumstances, and that we have we've already accepted jurisdiction, but that we have the ability to make that judgment under these circumstances. I think it is difficult for us to second guess, if you will, the judgment of a board or commission. There are a number of competing interests, meeting room scheduling, complicated items, number of people concerned, other factors, but I think we need to consider the reasonable expectations of the public and other parties, and if people believe that they are showing up, and if it is reasonable, particularly if the agency has expressed in the past that there will be an item and that people should show up, that creates an expectation that people should show up and be prepared to speak. If there are competing issues of controversy, a body should either provide for a longer meeting time or not have multiple controversial items such that a meeting is going to take forever. Those are serious considerations in how a meeting is structured. It's something that we, I assume, consider in structuring our meetings. It's something that anybody considers in structuring its meetings. So I am very much leaning to finding that the regulation was not reasonable under the circumstances, and I'm open to further discussion amongst the members. Thank you.
Member Washburn?
This is a tricky one, but I want to, I'm listening very carefully to what Member Pilpel says because he was there. And I also think that it seems to me that the taxi drivers had expected an item regarding their business since it had been some time, and there was, I guess, a last-minute change in the agenda. It was enough time was given. It was noticed properly, but prior to the formal notice, they were expecting to have an item dedicated to their matters. So, and then the fact that general public comment was not, which was their opportunity, given that they were there to speak, was delayed beyond what it typically would have been. I'm leaning towards also believing that it was not a reasonable, it was pure mismanagement of the time and the meeting to have decreased the amount of time the members of the public had to speak during general public comment.
Does anyone have any more comments or questions for either the defendant or the respondent? Well, I have a question for the respondent. Can you come back up here, Ms.? Thank you. I just want to clarify for all of us that weren't there, and Member Pilpel just clarified, or just tried to explain being there. So the taxi drivers issue was taken off of the agenda the Friday before the Tuesday scheduled meeting.
It was never on the agenda. The agenda as posted never had an item on it.
Okay, so why were just to explain to me, I mean, I went through all this paperwork, but so why were they all there anticipating they were going to be able to speak?
The director of the Taxi and Accessible Services Division holds taxi town hall meetings with the industry to solicit their comment and input on matters that are pertinent to them. At that meeting, and I can't speak for her because I wasn't there at that meeting, but she clearly, according to Mr. Snyder and Mr. Toronto, stated that she was bringing an item forward to the board. I don't know, why that never came forward. It may not have been ready. There could have been additional legal review necessary. I don't know the reason why. But the item in the agenda as posted was never included a taxi item.
Got it, okay.
And that is disruptive. It's clearly disruptive to the industry, and at the meeting is disruptive for the board because what they have are a number of people who come to the meeting and they're clearly upset, and there's nothing before them. So it is a very disruptive and a confusing situation, which, as I said earlier, our chairman is putting measures in to make sure that doesn't happen, and the director as well.
And so since it wasn't an item on the agenda, during public comment, that's my confusion, though, because we have faced the same issues with public comment and trying to limit if it gets really crowded, and it is it's up to the chair. But why would they, knowing they didn't get the opportunity to speak, and it was such a passionate topic, why wouldn't they give them more than 1 minute for that, like 2 minutes for that particular thing, particularly because the other items had been given 2 minutes, just since they were there in goodwill, I guess?
Yeah, well, first of all, there's no way of knowing that it was a passionate topic until they started talking. So the board doesn't know that it's a passionate topic. The board knows that when people turn in a speaker card, they have their name on it and they've checked off, that they're here to speak under public comment. issues that they wish to raise. Could be many. And it's not that the board or, I would know at that point that what they'd been told, the week before.
Got it.
It's unfortunate, and it is what it is.
Got it. Member Nee?
Ms. Boomer, ordinarily, how many taxi drivers show up at a meeting?
It varies.
Okay, what's the range? What's the average?
I couldn't tell you what the average is. I would say at any given meeting, normally, if there's not an item on the agenda, it could be 5 to 10.
Okay.
It could be several hundred.
How many were at the meeting that is under discussion here?
Well, in terms of speaker cards, for public comment, I had 33.
For general public comment?
Yes, but not all of them were there for taxis.
Okay, but about how many taxi drivers were at that meeting?
I don't
Do you
know. I don't know.
Were you at the meeting?
Yes, I was.
Mr.
I would have to look at the minutes and do a count.
Mr. Schneider or Mr. Toronto, can one of you give us an estimate as to how many taxi drivers attended that meeting? At the microphone, please.
I'm gonna. This is somewhere between fact and guess, but my guess is somewhere over 30 to 50.
30 to 50.
Yeah, and
Okay.
on the complaint, I put down the index to the SFG TV comments of some of the more notable ones.
Thank you.
There were actually 33 people who spoke under general public comment.
Okay,
and those who showed up and chose not to speak for whatever reason, I don't know.
Okay, but you're saying that in the ordinary course of events, maybe 5 or 10 will show up. Now at this meeting, you have, according to the estimate of the complainant, as many as 50. And I'm having difficulty believing that with anywhere between 30 and 50 people to speak on an item, the commission wouldn't detect that somehow there was a little bit of passion stirring in that gathering. That's all I have.
Member Sims?
Thank you. I think I guess my question is, you did make a statement that the board does not, following up on Member Nee's question, you made the statement that the board does not know a particular passionate topic before the meeting. And do you think that's genuine, that the board doesn't know the controversies in nature of its own agenda or items that may be on its agenda or items that were discussed at, I think it was a taxi cab?
A taxi town hall. No, they're not aware of the topics. The topics discussed at a taxi town hall meeting are not known by the board. Mm-hmm. What the director says, these are taxi town hall meetings that are 4 hours long. They cover a multitude of possible topics. Mm-hmm. It is a discussion between the industry, taxi drivers, color schemes, et cetera, and the director of taxis. There's no way to really know what of those items is coming to the board at any given meeting until the item gets to me, and that's when I know. And if it doesn't get to me, then I don't know.
But you understand kind of the standard that we have is reasonable regulations or reasonable time limits, and D of 67.15 goes on to say that the policy shall not abridge or prohibit public criticism, and then it goes through, and then at the end you say, on any basis other than reasonable time constraints adopted in regulations pursuant to this. But the time constraints can't be created based upon unpopular topics or
and they're not.
But you said that. However, the fact that your chairman's exact words were, considering the hour, and we also have a major issue coming up in our closed session, we're going to limit public comment to 1 minute. So then when we go back and look at the record, and the closed session was a very short period of time, it's kind of hard not to suspect. And, you know, my kind of standard is not reasonable doubt. It's just kind of preponderance of the evidence that there was something more there.
No, I understand. And without the issue that was scheduled to be discussed in closed session was not discussed in closed session. And so the chairman had understood that the item was going to be brought for discussion under anticipated litigation, and it was not brought forward. The chairman was not aware of that.
I mean, you're asking us to put a lot of trust in you.
I know. Yeah.
I'm just saying. I'm being honest. Okay.
Yeah. I understand.
Does anyone else have any questions or comments? If not, do you?
I just want to say I don't sense that there's a lot of dispute about the facts. I think it's really a question of judgment and how much what we want to do about it. I would concur that there were probably 40 or 50 or more taxi people there, of which, you know, some number in the 20s spoke. It was less than 33. There were some number of people who spoke not on taxi issues. I didn't come to speak on taxi issues. So, it's up to us to see what to do.
At this time, I know you walked all the way back there. Mrs. Boomer, would you care to offer a rebuttal or any final comments or anything like that? Okay. Then at this time, Mr. Schneider, I'd like to offer you the same opportunity for 3 minutes to offer any rebuttal or conclusion before we decide what we want to do.
Just a couple of things. It might have been possible. I've never been a chairman, so I can only appreciate how tough it is to do a job when there's a lot of people at a meeting. But also, the chairman needs to be somewhat sensitive to what's going on. And maybe with the chairman having seen the number of people there, he could have asked how many people wanted to speak, and then could have figured it out from there rather than just simply announcing it as there's only going to be 1 minute. But I'm a big Yogi Berra fan, and I don't know if Yogi Berra ever said anything about due process. But if he did, and if he ever talked about making the right, wrong mistake, I know he one time said that they lost a bunch of games because they made too many wrong mistakes. Well, I think there's a way of making the right, wrong mistake. In making the right, wrong mistake, what you want to do is give the benefit of the doubt to the citizenry and let them speak. Thank you.
Thank you. At this time, I'd like to open up and see if there is a motion to find a violation of the Sunshine Ordinance.
At the least, and certainly open to additional further friendly amendments from the rest of the members here. I would certainly find a violation, again, at the least, for 6715D. I'm sure that we've heard sufficient testimony that would certainly stipulate why that is quite obvious.
I'll second for discussion purposes.
Okay.
Madam Chair.
Member Nee?
Yeah. The question here that's before us is whether there was unequal application of the time limit. And I think the laws are fairly clear that time limits can vary between items, not within items. And I have seen no indication or evidence that there was unequal application of the time limit within any of the items talked about at that meeting. So, I think that the conduct of the taxi commission in this matter was far less than exemplary, but at the same time, I don't see a violation of sunshine.
Okay. You mean do you mean the MTA?
Yeah.
Did I say, what
The
did I
Taxi
say?
Commission Board?
Oh, my mistake. Thank
Okay,
you.
so
Thank you for the correction. I mean the MTA. I mean the MTA Commission. Again, less than exemplary conduct, but I don't think it goes to violation of sunshine.
Yeah, Mr. Schneider, I'm kind of, I've kept quiet because I've read this many times for the past few days. I'm kind of inclined to agree with Member Nee. Note the date and time because that doesn't happen much. But on this, I'm just going to be blunt. What happened to you was really stinky. I mean, it was a real bummer. And there are times when I sit on this task force and all we can do, we have this very narrow ruling, this 30-page, 67, code and whatever. There are times when I really wish I could be like, the nuns in the Catholic school and just rap somebody on the hand with a ruler and say, you shouldn't have done that, but, that's not what this commission can do, so I'm kind of inclined to, but I kind of compassionately understand what you're going through. I wanted to acknowledge that.
Member Pilpel? Oh, can I get Member Oka?
Yes. Frankly, I'm never in favor of 1 minute time limits for public comment on anything. I think if you are organized in your thought process, you can get everything that you want to say said, but 1 minute seems to be a little less than even the most eloquent of speakers can get all their thoughts out. So, but having said that, I was at the town hall meeting that Director Hayashi said that she was going to forward an item to the board, and it never made it to the board agenda. So that happens, and it happened a few times when I was a member of the board. So I know those things happen. Yeah, sorry. This microphone doesn't want to stay up, so, but I would like to see us. I don't see a violation either because if it was stated that public comment is limited to 1 minute, and I'm not sure because I was not at the meeting on the 16th. But I don't see a violation either.
Thank you. Member Pilpel?
Yeah, just to clarify to Member Monet on the motion, I'm not sure if I heard you say 67.15C or D.
D. She said D.
Okay. Okay. I would suggest that I'm not sure if the basis for, I don't think any public criticism was prohibited. I'm not sure that any abridging or limiting of time was on the basis of performance or other reasons that are stated in D. I would suggest that if there was a violation, it was of 67.15C about whether the
Sure.
regulations were reasonable.
I'm open to changing it to that.
Okay. Second accepts.
Member Sims?
The reason I would say it's more perhaps D than C, and I would be inclined to find a violation, it's just because I do not believe that the time constraint was reasonable under the circumstances and the totality of the circumstances. I do understand that I can only look at the record, and the record shows that clearly it would be very, very hard for this commission commission not to realize that there was some heated passion in the room, and the individuals wanted to talk about a topic that was passionate, and for them to then limit that comment to 1 minute because there was no agenda item because they failed to put it on the schedule. The commission had to know that this is where those individuals had their chance to speak regarding public comment and regarding this issue that unfortunately was not agenda'd. And in my view, they were attempting to abridge or prohibit that comment, or at least limit it. And the whole terminology of abridge is to limit. And I feel that they were attempting to limit that comment and perhaps the public discourse. It doesn't matter for which side, but they were trying to limit it. And it's very rare that member Nee finds a violation, or I find a violation and member Nee doesn't. I understand that, but I think maybe I just am a little bit more skeptical, and I think under these circumstances, because I'm so skeptical, the balance leans toward finding a violation.
Madam Chair, can I just a point of clarification? Is the motion to find violation of 6715D or C? I think it was amended.
D.
I had initially said D, and I said that I would be open to changing and or adding to it, but I do agree with the assessment that member Sims has presented. I mean, that was essentially the basis of why I brought it to the task force.
Yeah.
Can I let
Through the chair, the motion right now on the floor is for 6715C. It was first. It was D. It was first and second, and then it was amended, and this first and second accepted. So it's 6715C that's on the floor now.
Okay.
And I think C is reasonable too, because it's the concept of it is it must be a reasonable regulation. Under the circumstances, the regulation wasn't reasonable. I would go further and say C and D, but I'm fine with C, just C.
To some, member 3, Assistant DA Threet, please.
Through the chair to the members, just to try to illuminate a little further the considerations, there's a case cited in the memo that I'll give you a little bit more information about for your decision making. It's Chaffee versus San Francisco Public Library, and in that case, James Chaffee, a citizen activist around library issues, brought a case in the courts and up through the appellate courts where he challenged a limitation on public comment on items that was less than 3 minutes, asserting that the ordinance required 3 minutes for all items. And the court gave a lot of discussion around both of the sections that are called out here in the complaint, 67.15, and also the Brown Act section governing reasonable regulations. And the court generally gave great deference to the discretion of the chair in setting these regulations, so long as they were not set to such a tight limit that it was impossible to give meaningful public comment, and also so long as they were not designed to discriminate among viewpoints. So in that case, as a general matter, with those two caveats, as a general matter, so long as the limits were uniformly applied for a single agenda item, the court felt that was okay. Now, that doesn't necessarily answer the questions before you, but that's sort of the framework within which the court operated.
Thank you. Member Washburn?
I tending to agree with Member Sims, although I'm not sure I'd go so far as to suggest there was an intent to not give the taxi drivers a chance to speak their mind. I mean, it had the effect of doing that, but I don't know if the intent was there. So I'm clear about C, less so about D. But the issue is for me is what's reasonable, and so up to 3 minutes. So 2 minutes seems like a good amount of time. How about a minute and a half? Member Oka said, well, a minute is not a whole lot of time. A lot of people, particularly if something is complex, if you're upset about something, if you're haven't testified before, if English isn't your first language, it's going to be hard to make points you want to make in a minute's time. So a minute's pretty short. And, given that we allow up to 3 minutes, it seems that 2 minutes is, it's less than, what is customarily allowed with a reasonable amount of time. So I think 1 minute was cutting it awfully short and had the effect of really limiting what these members of the public had to say. So I mean, I think this is an opportunity for our body to think about, okay, we're the ones who are charged with interpreting this law. So what's a good amount of time for a person to be able to to make a statement? I've had to limit myself to a minute from time to time. It's real hard unless I have everything written out carefully. So, and trust not to stumble. So I'm sure about C, less sure about D, but I tend to err on the side of supporting members of the public always.
Well, as someone who does do the limiting of time for public comment and have been chastised for it, I think that it is up to the discretion of the chair, and I do think in the spirit, or however you want to say it, you kind of look around the room and see how many people are here and what you can get through the items necessary. I guess the one thing, I agree with Member Nee, because the idea that I think they were wrong, the MTA, in that their representative for the taxi at the town hall, it made implications and implied and had you guys thinking that you were going to come and be able to speak to an item that was on the agenda that was not on there, is problematic. But there was no item on the agenda. So for public comment, it is at the discretion of the chair. But I do think that the minute timeline is a bit harsh. So, but it is at their discretion if we stick to the law. And it's someone seeing that there is passion. It is up to them to say, you know what, there's more going on and we need to give a lot more time. But I wonder within our jurisdiction if we can't, and I think that's where Member Nee was going, it is up to their discretion. So if they gave a minute, as harsh and as wrong as I may personally think it is still there, up to them to do that. I did want to ask Ms. Boomer, when there was public comment, was there other public comment other than the issue of the taxi drivers? Were there more people coming up talking and everyone was given 1 minute?
Correct.
So there were other issues out there in public comment? Okay. Okay. Thank you.
I also just urge all of us as a body to really consider what kind of precedent we might be establishing with this kind of case, depending on how we vote, especially if we do vote to not find in violation. I urge us to all just sort of think about, in all seriousness, the kind of precedent that would be establishing.
And I agree, and to speak to your case, but I'm going to go back to Member Nee, because I think that it is about the precedent that we are serving. So then when someone comes to Sunshine or to another board and saying, you only gave me a minute and a half and we were really passionate about it, you're opening up something, because it says in the bylaws that it is up to the discretion of the chair. So I think we got to really give some real thought to it. And I agree in theory, this was wrong because there was a passionate topic and you see people standing there, so no one can say anything. I work in TV. I know what a minute is, and that's no time for something that you're particularly passionate about. But it was at their discretion, and everyone was given that same amount of time. So it wasn't like, oh, the taxi issue was given a minute, and this was given a minute 30. So, I mean, it's a bit like it's a moral issue to me. Like, I'm like, that's wrong. But then when it comes down to it, the jurisdiction and what it states and what 6715 is up to the discretion of the chair. So, Member Nye, I know you want to respond. Do you?
No, I've said all I need,
Okay.
all I wanted to say. Thank you.
Great, thank you. Any other comments? If not, we have a motion, and it's been seconded on the floor, correct? Okay.
I just wanted to clarify. So I heard elements of C and D.
C is what is.
C is the motion.
C is the motion. I heard in discussion elements of C and D. I'm open to either or both, frankly. So wherever.
Yeah, it's C. I think we've just firmly adhered to C, but we appreciate and sort of see that.
So I'd like to open it up to public comment at this time.
How many minutes do they get?
And you get 2 minutes.
Thank you.
Thank you.
Uniformly across everything.
Tariq Mahmood, taxi driver. There were about 100 cabs circling City Hall. Roughly about 100 people sitting in the City Hall. And then they were tossed out, and the item was general public and pushed down. And the other party was given an advantage over them. These 100 people, roughly if you stay there 3 or 4 hours, you lose about $100 to $120, which includes your wages and the money you pay to the companies. So these people were sitting there losing $100, $120 and not given a chance, number one. Number two, another statement made by her that board is unaware about town hall meetings. Board is fully aware. How come? March 19th, there was a meeting and there was a report coming called HARA report, which is HARA is a consultant for MTA from Canada. And that report was supposed to be there, and they announced, even the chairman, Tom Nolan, sorry, HARA report is not here, public is here, hundreds of people, 300 people. Sorry, we don't have that report, so we didn't put it on the agenda this time. So they do have every information which item is coming on agenda, even before coming on agenda. But then they say, oh, sorry, we couldn't make it this time. So there were people, they were aware. Now, after waiting 3-4 hours, the driver has to go return the cabs by 4:30, change the shift hands. Otherwise, they are under penalty charge, double, triple rates. They have to start leaving. The bar, in your case, is very high for these people. All these people, mostly immigrants from all over the world. I've been from Pakistan, the people from Bangladesh, Sri Lanka, Nepal. These countries, they have gone through a hell in their democracy process. So here they come and they expect you treat them fairly. With 1 minute, person like me who have spoken 100 times, maybe I cannot put my mind even together. So there's a wrong
Speaker's
statement.
time has expired.
I'm sorry?
You can finish. Yeah, that was 2 minutes.
Okay. And plus, we inform, agenda is posted on Friday, and we have to inform the driver a week before when we are told by town hall meeting, it's coming this week. We go to the driver, we distribute 2,000, 3,000, 4,000 flyers. It's on this meeting. And then suddenly we are thrown in the water. No, it's not on this meeting. So these people are lying. The standard should be higher. And 1 minute, how come you can say, okay, next time you have 10 seconds? What can I do in 10 seconds? Please, thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I think what we have here is a case of what we noted as a moral hazard. As this previous speaker said, what if they come in here and say, well, we're going to give them 30 seconds, 15 seconds. At some point, you need to give some guidance to these bodies as to what is an acceptable level and where the bottom is. I attend a lot of meetings. And the police commission has a habit, and we talk about discretion that the chair has. They put out the agenda, they control the agenda, they can arbitrarily or whatever change the agenda, and the police commission has a habit of doing this. They have a closed session on the agenda, They come in the beginning and say, oh, we might have to change the agenda. They carry out all the business they want to carry out, like the chief's report and the OCC director's report and whatever, and they go, oh, okay, we have to go into a closed session now. And all the members of the public who came to speak about certain items are left in this quandary of how long are you going to be gone? I don't know. I have sat there on 4 different occasions where the police commission went into closed session. One was for a half an hour, one was for 4 hours. But the bottom line was when they went into closed session, all of the people who came to speak, counting on the agenda that was placed before the public, were denied the ability to do so. Now, what really gets me is I went to the police commission and I said when they did it the 4th time that I was actually there and 3 other times when I had watched it on SFG TV, I said, you know, be honest with people. If you're so concerned about the cost of the witnesses and the attorneys and all this other stuff, then be honest and put that first on the agenda and let the public clearly know that that's your priority. And they got ticked. They said, oh, we appreciate public comment. It's just we need to change our agenda under the needs. And it sounds like in this case is what they did. And I find it hard to believe that the chair had no idea that the closed session wasn't going to have anything in it.
Thank you. Is there any more public comment on this topic?
I'm Peter Warfield, Executive Director of Library Users Association. I'm not a party to this, and unfortunately, I wasn't able to hear the earlier part of your discussion. I would like to say that it's shocking to me to hear, first of all, the chair unequivocally giving only 2 minutes. She's heard about this before from me and others, without regard to how many people there are, without any sense of any reason for shrinking down public comment, which is normally understood to be 3 minutes. Where do I get that from? I would like to know where you get the idea that it's up to you to cut back public comment to whatever degree you decide is appropriate. Section 67.15C. And I'll read it in full. A policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B are carried out, including but not limited to regulations limiting the total amount of time allocated for public testimony on particular issues and for each individual speaker. Each policy body shall adopt a rule providing that each person wishing to speak on an item before the body at a regular or special meeting shall, not might, shall be permitted to be heard once for up to 3 minutes. Time limits shall be applied uniformly to members of the public wishing to testify. Now, is there any meaningful protection for the public to make public comment if the chair has the discretion to shrink it back to what? 30 seconds? 10 seconds? 1 second? No. This is meaningless except in the sensible interpretation, which is I can talk for as long as I want, up to 3 minutes. Not 3 minutes if I only want to talk for 2 minutes or 1 minute. I get the choice, and I'd like to know what the previous speaker that you gave extra time got so that I may have equal time additional to continue with my point. Will you tell me how much time the previous speaker got extra?
We didn't time it, but I'm sure it's about 20 seconds, 20 to 30 seconds. So why don't you finish that thought? And then
So the other problem is that you do have to give folks equal time and not preference to this or that individual or group, which unfortunately I have seen. I think that you're really, really playing with fire and with democracy when you shrink back as you do in these meetings, and when you talk about, well, maybe we ought to this and that. There's nothing in the law. Show us in the law that justifies less than 3 minutes. Thank you.
Thank you. I'd like to have Assistant DA Jerry, Mr. Threet, City Attorney, respond to you. Mr. Warfield?
Through the chair, the question has come up repeatedly, and it's in this case as well. In the case that I cited to the task force, it was specifically argued, and it was the position of Mr. Chaffee, that he had up to 3 minutes at his discretion and not at the discretion of the chair. The appellate court rejected that argument very clearly and said that the discretion was the chair's discretion, so long as the time limit was not so constrained that an individual was unable to express their public comment. And the memo in the packet cites to the actual citation, and members of the public are free to review it on their own.
And that was appealed.
Thank you.
Correct. And that was appealed, and I mean that's the appellate decision, and wasn't.
Yes,
it didn't go up to the California Supreme Court, or
No,
it was denied.
There's been no Supreme Court decision on this issue, but that was the Court of Appeal for the First District.
Published opinion.
Yeah.
Thank you. Is there any more public comment? If not, I'd like to take a vote on the motion that is. No. Madam Clerk, I'd like to take a roll call vote.
Member Nee? No. Nee, no. Monet?
Aye.
Monet, aye. Washburn?
Aye.
Washburn, aye. Pilpel?
Aye.
Pilpel, aye. Sims?
You say Sims?
Yes, Sims.
Aye.
Sims, aye. Highland?
Aye.
Highland, aye. Oka?
No.
Oka, no. Fisher?
No.
Fisher, no. Grant?
No.
Grant, no. You have 5 ayes and 4 noes.
So the motion fails. Madam Clerk?
Item number 6.
Thank you.
Item number 6.
Pardon me. I believe it's time for item number 4.
Oh, I'm sorry, yeah.
Okay. Public comment, item number 4.
So this is general public comment on anything that is not on the agenda for today. Sir?
Hi.
Hi,
Good
and I'd
evening.
like to
Barry.
give, for public comment, everyone 3 minutes.
Hi, thank you. I'm Barry Toronto. This is my favorite body. It should be a commission, and I wish that somebody in the Board of Supervisors would put forth to make this a commission, because I think you do very important work. And I haven't been here a long time. The issue that was brought before you was delayed so long because you guys couldn't operate because of the politics. And I think it's important that the politics gets taken out of how this commission operates. Unfortunately, it's not, because you really are here because of a vote of the public, of the electorate, to protect the rights of the public to participate in city government. And to have access to public records, and so it's a problem that your situation, and finally it got resolved that you can meet again, and I've known a number of members of your task force. I want to call it commission, task force over the years, including 3 of them here today. There are a couple of 3 other issues. One is the relationship you have with the Ethics Commission. I'm very concerned that the Ethics Commission does not take your complaints seriously. That where it goes from here, once you decide, bothers me a whole lot. Because it shows how ineffective that the Ethics Commission has been regarding the morality and the ethics of violating Sunshine Ordinance regulations. And which brings up the other concern is I brought 2 complaints against one of your commissioners, and that bothered me that he participated in the vote because of the fact that director member Oka and I have not seen eye to eye many issues, and his involvement with certain parts of the taxi industry has made it difficult for me to see him as being an impartial person on a lot of issues, and that's why I'm bothered by him participating participating in the vote today because of that. He claims not, but I have asked the Ethics Commission to deal with these issues, and they basically to tell me to go nowhere. Even though they've tried to take my concerns seriously, they don't. And I'm worried about how they do it with you. And the last one, if I could make the point, is that the representative of the respondent, the city body, who represents them. I love Roberta. Roberta's been very helpful, very nice to me, and does what the board of directors and director says. Sometimes I think she oversteps her bounds, but the point here is she had to represent the board of directors, which I think is wrong. I think Tom Nolan should have been here. Other bodies send their people, send their directors. Look, you got the director of the Ethics Commission right here, and for one of the items, and you don't have a risk in here to talk about this item or Tom Nolan, and I think that's wrong in terms of who actually made the decision that brought the complaint to you in the first place. Thank you
very much.
Ms. Osbury, if you could let me know when I have 1 minute left, please. Members of the task force, I want to sort of agree with the previous speaker. I was at and had a complaint before the Ethics Commission when they just in one night took all of the years of referrals that they still had on their books and basically dismissed them all. They had no hearings, did not discuss or look at any of the evidence that this task force considered. And to add insult to injury, not only did they decline to enforce your rulings, they actually made motions and voted to find no violation in almost each case. In other words, they could have simply chosen to take your recommendation and your finding of violation and say, well, we can't see any way of punishing the person, or we don't see what the punishment would be, or we're going to decline to punish them. But they did not choose that. What they chose to make a motion to say, we are going to find, without any investigation on our own part, that there was no violation in each of these cases, and voted unanimously to do that. Now, what does that say to a member of the public who has to spend literally, in some cases, I have one case that is going before ethics where it is dragged on now for 20 months. And I am going to ethics at the end of this month on the 22nd, and I have already written a letter to the Ethics Commission saying I have no belief at all that you will hear this fairly. I have looked at the investigation you did, and the bottom line is went no further than the Good Government Guide, which is what you are basing all of your decision on, and you didn't look at any of the findings or the deliberations or discussions of the task force. You didn't look at any of the meeting agendas or minutes or recordings of the commission that was involved. You didn't do anything other than pick one simple thing and then simply say,
1 minute.
Thank you. Then simply say, we are going to do this in a way that completely dismisses all of the work of the task force. Now, my understanding of this law is you are the body that interprets this ordinance. You are the body that decides what the violations are, and for them to then counter what you did by taking a vote to find that all of the cases were not violations is simply a slap in your face, especially after you spent 2 years working with them trying to get in place regulations for them to hear these cases. They took 2 violations against people who couldn't be held accountable, and every single managerial or supervisor or elected official, they went and took a unanimous vote to find them to have not violated the ordinance, completely in contradiction to what you had decided.
Thank you. Hi.
Hello, Commissioners. My name is Doug Comstock, and I'm here because our friend Susan Monet is leaving. And Susan has given us so much hard work, and we do appreciate it. The San Franciscans for Sunshine truly do appreciate the work that you do, all of you, even though the rest of the city may not. And by that, I'm sure you know exactly what I mean. Suzanne, could you come forward? Thank you so much for this, for working so hard on this. This heavy green glass paperweight is our little token. We just get a picture of you accepting it. Thank you so much. Thank you for your work.
If I may let me know when I have a minute. I promise I'll be as quick as possible. I honestly just wanted to thank you all. You're all just such valuable colleagues to me, serving on the Sunshine Ordinance Task Force for the past 4 years. 4 years, time really flies. It has been an absolute honor and a pleasure. It certainly opened my eyes to just how important advocating for open government and supporting the public of San Francisco, any group, is just so valuable, so needed, and it's been a true honor and a true pleasure getting to know all of you, getting to know the advocates here in the public area, and just serving the city. So thank you so much.
Thank you so much.
Once again, Tariq Mahmood, taxi driver. General public comment. In 2010, taxi drivers start flocking on City Hall. They were crying, they were screaming. Their money was taken away by MTA. Millions of dollars, the medallions which were given to them for free for working 15, 20 years of waiting, MTA decided to sell them. Taxi drivers got their issues, and they came screaming. They were put on agenda and taken off the agenda, put on agenda and taken off the agenda. One of the protests, which started originally, brought about 200 cabs around the City Hall, hundreds of drivers inside. Second was medium, the third followed a month after, and literally 500 cabs, I would say. Wherever my eyes can go, I could see all the streets are blocked. And then the police came to clear them and not let them get near the City Hall. They block everywhere. They say, okay, here the towaway citation, we're taking your cars, or you run from here. So that was another trouble. But these people not allowed to speak. Items were always taken, told they are next agenda but taken out. Told they are next agenda but taken out. So much so that March 19th, we were told Hara Associate report, which is going to determine the future of this industry. They paid $400,000 to Hara, but they could ask us for free. And then that report, they start putting on every website, every information place. This is coming on March 19th. A month before, we have face-to-face meeting with taxi director with 100 people there. It's coming on 19th. It's coming on 19th. And then they pull it out. Oh, we didn't get it. There were 300 people sitting inside. We did all the email exchange with the Secretary Roberta, and we were awarded North Code, Light Code downstairs, plus room 400. When we came there, 1 o'clock, there was no North Light Code for us. It went on up to 1:30, then we were told, yeah, you can have one South Court. Then 1:30, they start setting up South Court, and then 1:45, we were told there's no voice from the TV. And then they turn on the TV, the chairs were hanging on the wall. They said, pick up the chairs yourself by. After that, there were 2 items, 9, number general public comment, 11, a particular item which the drivers want to speak. Secretary Roberta contacted me minutes before end of 9 that your driver cannot speak on 11 for electronic waybill. There is no electronic waybill item on agenda. We said, no, 11 is electronic waybill. No, it's taxi access. I said, but there is pages there of 11 saying electronic waybill. We were told, no, you cannot speak.
Speaker's time has expired.
Okay. So we'll be soon on this with a complaint to you.
Okay, thank you very much. Is there any more public comment?
May I?
Oh,
no, I'm so sorry.
That's okay.
I meant to say, if I can quickly say, I meant to put it on record that the reason for my resigning is just extreme work and time constraints, and I've already missed 2 meetings, and so it seems very unfair to continue to miss meetings, and so my organization has identified someone who's more available to fill the seat.
Thank you. Totally understood. And we appreciate everything that you've done. So, thank you. We'll miss you.
3 minutes?
Yes, 3 minutes for public comment.
Thank you. I'm Peter Warfield, Executive Director of Library Users Association. This discussion in general about how long people have, including how long they have in front of this body for public comment, has gone on since the beginning of your new regime, which, as you know, many people view and understand as being a highly political body now, with a highly political history, particularly in the last year. I did want to say thank you very much for Susan Monet's service to the task force, and particularly to the public in her service. And I wish I could say more, but I do have some things I would like to say here at public comment. I don't know what I have to do. I don't have a piece of glass to give you so that I can get a hug. A number of points I wanted to make. There have been cited in various times other rulings in places like courts with respect to, or allegedly with respect to, what an interpretation would be of sunshine. I'd like to remind you that you in San Francisco are the body that the voters said makes determinations about legality or illegality. You are it. There's nothing in this law that says you're supposed to follow this or that interpretation that somebody else has given. And as somebody, as you may know, who's been coming to the task force for many, many years, and for the most part has won cases, you, as a body, have frequently overruled your own deputy city attorney when you've asked for advice or when you've been given it. I particularly remember when your city attorney advised you not to find jurisdiction on a complaint that library users had filed, or I as an individual, because, in his opinion, it had no merit, and basically he prejudged it. Fortunately, as an example, that was something that the task force overruled, and so they did hear the case, and I believe I won that one too. I hope on April 22nd, when your referral to the Ethics Commission of Library Users Association comes for a hearing, that you will be there to represent the task force which has forwarded this matter. I have a great deal to say about that and the unfairness that I expect from that hearing, but I hope that you come and represent, at least as a witness, the task force in some fashion. Thank you.
Thank you. Is there any more public comment? General public comment? If not, then I'd like to take a 10-minute break and come back at 5:45. Thank you.
I'm a Dodger fan.
You would know. So I'll talk to you after.
I'd like to call the meeting back to order. Madam Clerk, will you call the next item on the agenda?
Item number 6, file number 12049, complaint by Ray Harts Jr. against John St. Croix, Executive Director, Ethics Commission, for allegedly committing multiple violations of its July 23, 2012 minutes.
Great. I don't believe that, I think both parties accept jurisdiction, so I'd like to call for a motion in a second.
So move.
Isn't Mr. Hart's right there? I can't see. Yes, right there. Okay. It's It's been moved and seconded. So I would like to pass the motion.
Public comment.
Oh, before I do that. Is there any public comment about jurisdiction on this issue? If not, then I would like to declare the motion passed without objection. Okay. There we go. I'd like to invite the complainant, up. Not defendant, sorry. Complainant up. Sir, you have 5 minutes to give us the details of your case.
Back to me when you're done.
Ms. Osbury, if you let me know when I have 1 minute left, please.
Oh, is this for us? Okay.
Ray Hartz, Director, San Francisco Open Government. I'd like you to consider this thought from Thomas Aquinas.
Can you make it smaller a little bit?
Sorry. Oh. Nope.
There it goes.
There we go. Figure out that the Thomas Aquinas teaches that willful ignorance of what one ought to know is a mortal sin. In other words, if I know something's wrong and I do it anyway, it's kind of hard for me to justify my actions. I'm not going to spend a lot of time going through the history of this. This is, I think, the 7th time this has been before the Sunshine Ordinance Task Force. You have ruled continuously and even more strongly in each case that the 150-word summaries belong in the minutes. Slowly but surely, through all these cases, every one of the justifications that various bodies have used to say this is not acceptable, etc., have all disappeared, and the last one standing is the Good Government Guide. So let's take a look at the Good Government Guide. And this first slide is just to show you the page in the Good Government Guide, and the red box is the paragraph we're talking about. You notice it is put into 2 halves, and the top half is simply a paraphrase of what the law says, and it concludes with the chapter. Below that line, the city attorney has added this to the Good Government Guide. The summary is not part of the body's official minutes. Now, how can someone come here and logically argue that putting 150-word summaries in an addendum is permitted by the Good Government Guide when the Good Government Guide starts the paragraph out with the fact that the summary is not part of the body's minutes? You can't say, oh, well, it's the same, it's in the addendum, and that's just the same as being in the minutes, and yada, yada, yada. And that's what the Good Government Guide says you can do. When the Good Government Guide starts out the directions with the fact that saying that the summary of the 150-word summary is not a part of the minutes in the first place. It's completely contradictory, and you're arguing both sides against the middle. Now, it also goes on to say, may do things. Nor does the body vouch for its accuracy, and the minutes may expressly say so. The summary may be included as an attachment to the minutes. The policy body may reject the summary if it exceeds the prescribed word limit or is not an accurate summary. It doesn't say shall, which is what the ordinance says. It says may, and this is a choice for each individual body as to how they choose to handle it. We have been fighting this case for 2 years. And every single time they have come up and said, no, it can't be in the body of the minutes, even though the law says that. Here's some question. Here is the question that was asked by the task force and Mr. St. Croix, who is the actual named person in this complaint. Always is, can we ignore the findings of the task force? Multiple findings against the Library Commission, a city librarian, the city attorney, and the Ethics Commission itself. They never ask, should we ignore the finding, or I think more critically, why do we want to ignore the finding? Why are they so determined to keep my little 150-word summary out of the body of the minutes? To abridge public comment. They don't like what I have to say. I disagree with them. I point out things that I feel they're doing that are inappropriate, and that's the reason we have open government laws. It's why we have the Sunshine Ordinance, why we have the Brown Act, and it's why so many times I believe this task force has ruled that the 150-word summaries need to be placed in the minutes where they belong, not somewhere off to the side where people are likely to miss them.
1 minute.
And I will conclude with one other thing. One argument that has been raised before but has not been raised in this particular case before you is the fact that the secretary or whoever is recording the minutes has an obligation to do a summary of the minutes. I'm not asking that they remove their summary or not do it. In fact, very honestly, I would be happy if they put their summary and my 150-word statement right next to each other so that people reading the minutes could see how badly they distort what I actually said. And I will finish with one last thing. This has been, continues to be, and will be a matter of constitutional freedom under the state constitution, the federal constitution, because I have the right to say what I have to say. And I have the right to have that represented in the public record accurately.
Thank you. Is there anyone here to offer any support to Mr. Hart's comments? If not, Mr. St. Croix?
Good evening, ladies and gentlemen of the task force. Before I get to the issue at hand, I just cannot let the characterization that was just presented on that screen go without telling you that characterization of the Ethics Commission's approach and my approach to these referrals as presented by Mr. Hart is categorically false. So there's two things I'd like to represent to you today. The underlying issue is, as we all know, whether statements submitted in writing should be appended immediately where the speaker speaks in the minutes or whether they can be included at the end of the minutes. The common practice, the customary practice of most bodies in this city since the advent of the ordinance has been to put them at the end. They do, I believe, have some discretion if they'd like to put them in the body of the minutes, as Mr. Hart's characterized, where the person speaks and their oral comments are summarized. However, the city attorney, as you know, has advised, and the Ethics Commission continues to advise boards and commissions that they may put these written submitted statements at the end of the minutes. The end of the minutes are part of the minutes, just like the middle of the minutes and the beginning of the minutes are part of the minutes. So it is the opinion of me and the Ethics Commission and of the city attorney that this satisfies the requirement. As a courtesy to Mr. Hart's, I directed the staff this year to start putting those statements, instead of putting them at the end, to put them at that part of the written minutes where the person speaks. This is only a courtesy, it is not a requirement. And it is not a written policy of the commission. I just felt that this was an accommodation we could make. Again, not because we have to, but because we wanted to. The other part of the issue that I'd like to address is at the meeting that we're talking about that happened last July, Mr. Hart spoke 9 times during public comment. He submitted 7 written statements to be included in the record. We included 6 of those statements. The 7th statement was excluded because we thought at the time that it exceeded the 150-word limit. Later on, we realized that we had made an error, that it was exactly 150 words, and it has since been included in those minutes. So we perceived our own error and remedied it. So that's basically everything I have to say. We have interpreted the law with the guidance of the city attorney as we think is appropriate to satisfy the requirements for the city, and that concludes my remarks. Thank you.
Thank you. Is there anyone here to offer any support or facts for Mr. St. Croix? If not, then I would like to open it up to the task force members to question the complainant, respondent, or have some conversation about this? Oh, Member Washburn?
I have a question for Mr. Hartz. So Mr. St. Croix said that he has directed that your summaries, I guess just yours alone, this wouldn't apply to other people, but this case is regarding your summaries. So for this July meeting, these 7 summaries, are they now in the body of the minutes?
I believe the document that was provided to this task force has them all at the end of the minutes.
I have to scroll down. I do this electronically. Somebody who has a paper copy can let me know.
They're at the end.
They're at the end. Okay. Well, maybe that's been changed.
Yeah. Did you mean since that point? Or
going forward.
Going forward.
Back and change.
So going. Yes, sorry.
Mr. St. Croix?
Can you come up? I'm sorry. Yeah.
So, Mr. St. Croix, you're saying that your policy from at some point, but from now certainly, is anyone submitting 150-word summaries to the Ethics Commission, those summaries will be in the body of the minutes.
At the point where that person speaks during public comment, the 150-word summary will follow their remarks as summarized in the minutes.
Okay,
For
so
Mr. Hartz or anyone else who submits those records, but I'm not going to direct the staff to go back and alter all of the minutes going back whatever length of time.
So when did you guys start that process? Just
I think it started with the February meeting.
so February. Okay. Thank you.
Thank you.
Member Pilpel?
I'm trying to be a little quieter, but I'm going to refer in the packet to a memo in the following item 7, starting at page 102 of the packet. Apparently there was a memo that issued from this task force May 18th of last year after some of us may have been appointed or around that time, but I was not aware of until recently, that states the task force's position at that time following action in December of 2011 with respect to this issue. That was the position of the task force at that time. I'm not sure if that's the position of the task force at this time. I think certainly reasonable people can disagree. Maybe other people can also disagree about whether in the minutes means at the point or as part of an addendum or attachment. But I think so long as the summary is included at some point in the minutes, whether it's page 3 or page 24 of a 24 or more page set of minutes, it meets the requirement, both of the letter and the spirit of the ordinance. And so I take issue with the conclusion that the past task force reached. I would like to, I don't know, what's a strong word? Repudiate? Rescind? Something. That position. I think if the summary were in some other place that were not accessible, not related to the minutes, it wouldn't meet the requirement. I note that it's not just the requirement of the Sunshine Ordinance to keep minutes in a prescribed fashion, including the requirement to include these summaries, if not more than 150 words. There's also a charter requirement that a record be made of the actions of a body, and I'm of the view that that more so constitutes the actions for purpose of record keeping, for purpose of an official record of the actions of a body of government, and that the minutes include those actions and may also include such other comments as the body reasonably chooses to include, consistent with the ordinance and whatever other laws. So I am not presently of a view to find a violation here, and I'm hoping that we're not going to just continue to see complaints with respect to every single body of government that isn't providing minutes in the way that the complainant and perhaps others would like to see them. I'm sure that will engender a little discussion here. Thanks.
Members, Member Washburn?
A couple of points. First of all, we've just heard Mr. St. Croix say that after hearing a number of cases where the Sunshine Ordinance Task Force has, through much discussion, determined that the common understanding of in the minutes means, we have decided means, for various reasons, in the body of the minutes where the member of the public spoke. We've just heard from the Ethics Commission that they're now starting to have these 150-word summaries put in the minutes. So, if we were as a body to say, okay, we were just kidding, we no longer feel that way, I think it would, given that it's not a straightforward matter, and we've used our, deliberative processes, and we've thought about it, and you can make a very reasonable argument, as we have, for the law stating in the minutes means in the body of the minutes. Why on earth would we rescind that now? I mean, come on. It would just make us look pretty darn flaky. We have the Ethics Commission finally saying, well, this is not an altogether unreasonable thing to do. And I could, talk for the next 10 minutes on all of our reasoning as to why we've decided that in the minutes means in the body of the minutes. But something Member Pilpel said that bothers me is that you're speaking to minutes as being a record of the actions taken, and that's true. And there's this big move in this building to have these action minutes, which, there's certainly an efficient way to do things, but they lose a lot of our conversation, our deliberation. They frustrate me greatly because I can't go back and remember, our conversation. But to say that that's the primary purpose, and then public comment is just something we can stick at the end, as if it isn't as important to have the public here speaking about matters that concern the public as, hey, this is what we're all here for. This is all about the public. This is our house, our government. So, we can't regulate public comment, stick it at the end is kind of an afterthought. It's what the members of the public have to say is important. We do summarize it, and for members of the public who want to make sure that their careful thoughts are memorialized in the record, the least we can do, I think the least we can do, we have to give them the weight that they should have. So I strongly urge the current constituents of this body to affirm what we've been saying for couple of years now about this matter.
Is there any more comment or questions? Just as someone who is new and who was not here for that May back and understanding this, and someone with kind of fresh eyes, when I looked at this, I didn't understand why I felt like it was up to each commission to choose, as long as it was in the minutes. The body of the minutes, to me, is the document. Like, our clerk does a document, and she now, and correct me if I'm wrong, Madam Clerk, you put it in the body currently now. because that's her preference. But I think that each individual commission, as long as it's in the minutes, and correct me and tell me what I'm missing, because when I looked through this and I looked through Mr. Hart's file and I saw how they did, public comment, and then they said Mr. Hart spoke at this time, but then they at the end put his actual summary in his words, which would make me happy because I don't want anyone paraphrasing for me, so we could see what he was talking about specific issues. And now Mr. St. Croix is saying it's not a requirement, but as a courtesy, and they thought about it, is a way to put the people's, it opened their eyes to the whole idea of putting it in the body if it makes, people, the public, happy and what this is the process and they want to do this, then it's up to their discretion or their clerk's discretion. I don't understand why, because they made a notation that Mr. Hart's, blah, 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 and then you go to the end, and then I read his words and not a summary, but it just said he provided a 150-page summary. So we go to the end. And then I went back and I was looking at the other thing, and then they said Mr. Hart's provided this, or whoever did, and I can read their words. And so, I'm just want you to kind of enlighten me a bit, because I think that it's up to each particular commission the way in which they do it. When I read the documentation of what they've read, I'm like, it is in the minutes. I don't agree when it's an attachment necessarily. I do agree when it is at the end. It's like item number 28 with the public statements from each individual member of the public that wanted to provide a 150-page summary. I don't see what's wrong with that. I do, and now that they're doing it this way, which is, if this makes it easier for the public and their ideas, and that's how they want their ideas to be seen in that body as they're going through the document, and they're doing it, then, it's great, but it's not a requirement. So I see the attachment, like I do see an attachment as something different. But when I see it at the end of the minutes, I still think that's the whole document. So I'm reading the whole document. I read our documents and I read our whole document. So it's just that Andrea, I know, puts ours in the body, but I don't think that it's up to us to determine that at the end is not the body. So if you could explain to me kind of the history, that would be better.
There is a long history here. It used to be that the 150-word summaries were an attachment that weren't always attached. So if you were reading the minutes online, they were virtually lost.
They weren't there.
So, but then the other matter is, okay, what the secretaries or clerks would do would be to write a summary of the person's, what they said, and put that in the body where it's supposed to be, okay? And so some members of the public were saying the summary wasn't quite accurate, didn't quite reflect what they had to say. Now, if they didn't provide a 150-word summary, then you'd have to go check the audio. But if somebody, in fact, wrote a 150-word summary, that was what they wanted to say, why not put that there in the body rather than at the end? Mm-hmm. So, I'm thinking, why not? It's not, it's not like it's a 5-page paper inserted in the middle. It's a little paragraph.
Got it.
So, I feel like, come on, just do it. and you can argue that, to be picky on the side of the public, having somebody have to look at the very end kind of breaks the train of, thought, and that's a fine point. But, we're just trying, we have interpreted the ordinance to just in plain English saying it should be in the minutes as you're following the record of the meeting rather than at the end.
But how do we find them in violation if that is not, we should, but is that a violation because they chose to put it still in the minutes? The attachment factor, I definitely agree. That's not a part of the minutes.
No, you're making, this is a fine point that you're making. And I mean, before when it was virtually lost because it was an attachment, then that was a bad problem. This is a little, I have to say it's not, it's better. But I mean, the fact that the Ethics Commission is starting to do this, okay, well, why don't we all do this? It's not an onerous thing, certainly. I mean, for the clerk's purpose, it's kind of easier rather than summarizing it, thinking about, am I capturing what this person said accurately? Hey, the person has said what they want to have
I
said.
guess so like Mr. Hartz is really diligent and he provides his 150-page summary. So that's the issue at hand. He wants his summary, his words put in there. And so that is what we're discussing here, because everyone doesn't provide a summary. Because I was reading at one point, I think you said they summarized something. You didn't provide Mr. Hartz, you didn't provide a summary one time, or maybe that was the other case actually, and they summarized something for you, and it wasn't reflective.
There have been 5 cases: 10054, 11054, 11071 with the city attorney, 11083 with the Ethics Commission, and I can't remember the last one. Okay. But basically, why I started this 2 years ago was the fact that they tried various things, and basically what they do is try to treat it as a footnote. And you're reading along, and it goes out of train of thought. You don't know how it relates to what other people had to say or what was being discussed. Some people obviously are going to miss it because they're not going to realize. Even Mr. St. Croix, when they first started putting it on the website, if you printed out a copy of the minutes, the statement didn't print. And the only thing that was there to indicate the statement was even there was a little number 1 in blue. And you had to know that you had to click on that number 1 to see it. And once you clicked on that, you couldn't get back to the minutes. So basically, they have gone through all these permutations. First, they didn't want to put them in at all. Then they wanted to do this. Then they wanted to do that. They wanted to do something else. And one thing that I want to point out is Mr. St. Croix has misrepresented this case in the sense that at no time has the Ethics Commission had a public discussion of this policy. They have stated numerous times in these previous hearings that it is their policy to place them in a certain place, and Mr. St. Croix has simply arbitrarily moved them to satisfy the requirements of the task force, and there is absolutely nothing to prevent him from going in the opposite direction next week.
Thank you. Member Oka?
Yes. The purpose of minutes is to reflect what went on during a particular meeting or what went on during parts of meetings. Nothing says that minutes can be a summary of what happened. I believe if you want to keep accurate minutes, you must almost do a verbatim transcript of what went on at the meeting. Some agencies in the city government choose not to do that. They choose to summarize what went on during a meeting. That does not satisfy the. As I read the definition of minutes, those are not minutes. If a member of the public wants to summarize his or her statement, that statement should be, and I believe must be, placed in the proper place at which the person spoke. And I believe it's not, shall we do this? You must do it. I believe that's my reading of what we're supposed to be doing.
Okay. Member Highland, I think, had something first.
Yeah, could I ask Mr. St. Croix to come up? I just wanted to applaud the fact that you are starting to do this as a courtesy, but I'm taking exception to your comment that you're decided that it's not worth the staff's time to go back in time to include these 150-word summaries in the correct place. Is that what you said earlier?
Yeah, I mean, my staff is overburdened, and
Not with cases from us, clearly. I think.
Be that as it may, sir, my staff has a lot to do. This, as I stated, this is not a requirement under the law. I'm doing this as a courtesy. A few minutes ago, I told you I directed the staff to do this. I did say it's not a policy of the Ethics Commission, so I don't know how Mr. Hart says I mischaracterized it. He's absolutely correct. A week from now, I can tell the staff to go back to doing it the other way. The statements summarized by people who speak at meetings are recorded. What we're saying right now is being recorded. Our meetings are recorded. If whoever drafts the minutes mischaracterizes what people say, there's opportunities for that person or commissioners or the public to say this needs to be amended. And certainly when people state things on the public record, either members of boards of commissions that are present or other members of the public can actually speak to what they say, and you know, in case they have an opposing point of view. These statements are not subject to amendment, they're not subject to correction, they're not subject to redaction. They're printed as they're handed in. Commissioners don't see them the day of the meeting until they get copies of the minutes. Members of the public don't see them until the draft minutes are available. My history with legislation tells me that there are sometimes unintended consequences. And if it comes to the point where including these written submissions within the minutes where the person spoke are being perceived as having been part of the discussion at the meeting, as opposed to something that was submitted in writing, I may have a problem with that. I don't want people reading into things that didn't happen in the meeting as if they did happen at the meeting. I think that the Sunshine Ordinance gives people this ability because they are limited by 3 minutes or 2 minutes or whatever. And sometimes people are better at writing down what they have to say as opposed to expressing it publicly. Public speaking is often difficult. So I think this courtesy was extended, this ability to communicate in writing as well as orally so that people are able to comprehensively state what they have to say for the record. But again, the people that are in charge with enforcing these have read the law as it's written. It says it has to be in the minutes. It doesn't say where. So while I appreciate that the task force members, at least some of you, feel that it's appropriate to put it where that person spoke, and again, we're trying it to see if it works, I don't think the law requires it. I solidly believe the law doesn't require it. And I'm hoping you'll make a decision based on what the law says and not what you think should happen. If this works out and the Ethics Commission, I understand the Library Commission is going to start doing this, it may become the accepted protocol for the city, you know, and that may be a good thing. But in terms of the decision you have to make, it's what does the law require? And our interpretation of the law is that as long as it's included in the minutes, you know, whether it's at the end or in the middle, that satisfies those requirements. Forgive me, I didn't mean to go on that long, but I wanted to be clear.
It's helpful. Member Sims, do you have a question?
Mr. St. Croix. Hi. Just stay there. I think this is primarily the issue I have with your interpretation. You have specifically said that your interpretation of the law is that this is the case, and that you don't see anything in the law that requires this. However, the Sunshine Ordinance Task Force is the only body who can interpret the Sunshine Ordinance Task Force under 67.30. I don't really see under 67.30, which gives the city attorney the right to interpret the Sunshine Ordinance Task Force or the Ethics Commission the right to interpret the Sunshine Ordinance. So I take I'm extremely kind of upset that you have said that you, of the Ethics Commission, have interpreted for the rest of the commissions and boards, and that the city attorney has taken upon themselves to interpret for the rest of the bodies, that this is the correct interpretation of the Sunshine Ordinance. When the Sunshine Ordinance specifically says, and I'm not quoting, or I'm sorry, I am quoting, I'm not summarizing it, the task force shall advise the Board of Supervisors and provide information to other city departments on appropriate ways to in which to implement this chapter. Not that you can, not that the Ethics Commission can, not that the city attorney can, but that the Sunshine Ordinance Task Force. Now, we then turn to the section 67.16 regarding the minutes. The interpretation that can be made, this can be interpreted in many ways. You could say that the interpretation could be in the minutes, or you can in the actual where it occurred, or you can say that it can be at the end of the minutes. My belief is that we as a body should err on the side of giving the public the most access and the most ability for their voice to be heard. And so that should occur in the place, in the minutes where they spoke or where they are placing their summary of what they spoke. So it is important that that be there. And that is the interpretation of the Sunshine Task Force previously. And if I have anything to do with it, it will be the interpretation going forward. So it isn't up to you to change our rulings. Now, if it then goes up to ethics, then that's ethics decision. But ethics decision does not mean that is a ruling of the Sunshine Ordinance Task Force. You chose to not find a violation. That doesn't mean that interpretation then is incumbent for the rest of the city departments to then follow, because the ordinance doesn't say that. So that's where I kind of get a little heated, a little upset, because I don't see where you are finding your power to interpret the Sunshine Ordinance Task Force in the way you interpret it.
Did you want a response?
Well, I just want to know where you get your power from to interpret the ordinance. If you can show me in the ordinance where it gives you the right to make one fell swoop of interpretation and one fell swoop for this one commission to ignore us, please show me that.
I don't think we're ignoring you. The Ethics Commission is charged with enforcing the ordinance, and as the enforcement agency, we also have to interpret it. And there has been historical tension between the task force and the Ethics Commission, because the task force finds violations that the Ethics Commission disagrees with. And through its deliberations, if the Ethics Commission declines to enforce something because they don't find a violation, that's a form of interpretation, and that's resident within the ordinance.
But what is not resident is that your failing to find a violation then takes away our ruling and our interpretation. The only body, technically, and I mean, I'm sure Mr. Warfield would disagree with me, the only body is a judicial body who can take away our interpretation or overrule our interpretation. But nothing in the ordinance says that the Ethics Commission, that would be giving a broad, even a more broader interpretation than what you are claiming we're doing. Because we're just trying to give the public access and the public the most ability to speak and be heard. And I don't feel like this interpretation is so unwielding and so much time consuming to the staff and the hours and what it takes to get it done. And it's simple. And you don't have to show up here, and you don't have to have any issues from this gentleman, Mr. Hartz. It's just done and taken care for. And I think it's actually easier. So that's just my feelings. Thank you for coming. And thank you for answering my questions.
Are there any more questions or comments? Member Pelpel?
Who could follow that?
I'm sorry, I'm not taking away from any of that.
Yeah,
I can't.
Going on after that.
But I did want to address.
Loudspeaker, please.
I did want to address that in part. We did a little quick research here. There is a charter provision. There are actually some related charter provisions. C 3.699-11 sub 10. 14B, 14C. It was contemplated that the Ethics Commission, in when the Ethics Commission was created shortly after or roughly the same time as the Sunshine Ordinance was being promulgated, that they would have a role with regard to both enforcement of the ordinance, but with regard to education and I want to get the language right here. Education and enforcement with respect to the Sunshine Ordinance, although it's characterized as public record and public meeting laws. So there is some support for that. It may not be as tight as you're looking for, Member Sims, but there, I believe, is some support for that, and charter provisions supersede ordinance provisions, although in this case I don't think that they're in conflict, but I believe that they do have some slightly ambiguous responsibility in this area. I hope that helps you a bit.
It does, but I think not to debate. I think the charter provision would have to specifically say that the Ethics Commission's decision regarding Sunshine supersedes ours some way, and it doesn't.
I don't think that it does.
It doesn't.
But I just wanted to give you that there is some stuff there.
Okay.
That's all.
I follow by saying that the ordinance is not written the best it could have been. We all know that. So we're really the keepers of the ordinance in the sense that we have to try and interpret it best we can with regards to Sunshine. And that was the point of my talking to Mr. St. Croix. I didn't like what I was hearing, that he decided what was appropriate before we even made a ruling on this. And that was the point I was trying to make originally. But I think David Sims eloquently took that and went with it. So,
is there any more commentary? Member Oka?
Let me be clear on something here. I do not see where the Ethics Commission can overrule the decisions that we, as the Sunshine Ordinance Task Force, render. If you can show me where the Ethics Commission has the authority to overrule our decision, let me see it, because I don't see it.
Mr. St. Croix, would you care to answer that? Are you overruling our decisions, in effect? Sorry to make you come back up. And then we can move forward.
The commission considers each referral from the task force as it gets them, and either determines that a violation existed or didn't. So there are times when the task force finds a violation, the Ethics Commission says either there's not a violation or it wasn't willful, or there's something else that disqualifies the finding of the task force. So I guess the basic answer is yes, because we don't always agree with the findings. My commissioners consider the referral from the task force and then the comments from my investigative staff, and they make a decision. In the last meeting we had not the last meeting, but the February meeting, there were 6 referrals from the task force with a number of findings, and the Ethics Commission upheld 3 of them, but dismissed the rest of them.
Okay.
So
Where in the city charter does it say that you can overrule the task force? Where? Show it.
We're the enforcement agency under the charter for public meeting rules, public meeting laws. That would include the Sunshine Ordinance. It's in the charter. And, we base our findings not only on the work of my staff, but on the advice of the city attorney. City attorney, as an elected officer, we believe, the highest authority in making these determinations.
Thank you. Member Washburn?
Just a point of information that the Compliance and Amendments Committee spent some great long time reviewing the proposed regulations of the Ethics Commission for our referrals. And after some time, we also had a joint meeting with the Ethics Commission. And there were regulations that came out of that meeting. And it was our understanding that the matters that we referred to them for their enforcement were supposed to be enforced and not reinvestigated. So I'm just, this is just a point of information. It's to be determined whether the Ethics Commission is in fact following their new regulations or not. So.
Okay. I'd like, what were we going to say?
Madam Chair, I just wanted to clarify when you asked me how the task force currently does their minutes.
Oh, yes.
Yeah, in the past, like if you look at, February 2013 and May 2012 minutes, originally they were placed as addendums, but through the task force and their edits, now they're in after the public comment section. So, to make that change.
So they're in the body, but you list them all.
Correct. Right now, currently, they're in the body as edits came in through Member Nee and Member Washburn. They're in the body following the public comment, whereas before they were in the addendum.
Addendum at the end of the document.
Correct.
Okay. And we changed that starting with February. When did you start putting the
So
public
that
comment
was May 2012.
Oh, so we started putting it in the body.
I did, coming in.
Oh, yes, you did. Okay. Okay, then at this time, if there's no more comments, then I'd like to offer.
May I respond to Mr. St. Croix's comments? Because he had quite a bit of time up here.
Sure,
Now I've forgotten what I was going to say. I think this comes back to what, and Deputy City Attorney 3 can comment on this, as the item called the Court of Original Jurisdiction. If I file a complaint with the Ethics Commission and they decide they want to interpret the Sunshine Ordinance and not find a violation, they have every right to do that, and you have no right to tell them they can't. And I think the reverse is true. If you, being the body, especially since you're designated in the ordinance as being the body who decides these things, if you decide it a certain way, they do not have it in their power to reinterpret your determinations. That is your power and your power alone. And if you decide otherwise, not only are you reversing 5 prior decisions of this body, you are giving away your ability to interpret this law. You're just basically saying to every city body, you can interpret it any damn way you want, and we have no ability to change that.
Great.
Madam Chair.
Oh, Member Nee?
I'd like to ask Mr. Threed if there's any section in the Brown Act dealing with minutes. I have just been looking through it in our Good Government Guide supplement, and I have found nothing. Maybe it escaped my eyeballs, and that's why I'm asking for an extra pair of eyeballs on the question.
Through the chair to Member Nee, there are no requirements in the Brown Act for keeping of minutes. There are limited requirements in local law that are in the Charter and in the Sunshine Ordinance, and they call out very specific requirements for the minutes. As a general matter, there's not a detailed list of requirements for what have to be in the minutes. So, for instance, in regard to Member Oka's comments that the minutes, in his view, have to be very detailed, almost verbatim transcripts, there's no such requirement in state or local law.
Thank you.
Okay, let's
just for what it's worth, my view is that 67 point, 16 is not only the most specific, but it's really the only requirement about the content of minutes. There are lots of requirements in the ordinance and the Brown Act elsewhere about the content of agendas, so that there are all kinds of expectations that are known and made clear about getting to a meeting. But with respect to the minutes or the record of a meeting, as was pointed out, they are few. The charter, with respect to the charter and that section of the ordinance, that's about it.
I'd like to offer the respondent opportunity. Do you want to offer a conclusion or rebuttal? Mr. Hartz?
Excuse me.
I can't see.
Respondent first.
He said he didn't want to. Okay. Mr. Hartz?
The comment has been made that this is courtesy to Mr. Hartz, and it isn't a courtesy to Mr. Hartz. It is a granting of the public in general the right to ensure that their free political thought and speech is accurately represented in the body of the minutes. And very frankly, the reason I started this is because the Library Commission had a habit of completely misrepresenting what the person said. In other words, they would take what you had to say, and if you said something positive to them, they would put that in the minutes, and that would be the summary. And they would exclude something that they didn't agree with. And so basically, it was up to their discretion. And the whole purpose of the Brown Act and the Sunshine Ordinance is that political disagreement, political opposition can't be suppressed. And the question that has not been asked of anyone at any of these hearings is, why is it so important for you to keep these summaries out of the minutes? Why do you want to block a person from getting their political free speech into the minutes where it can be read in the correct way in relation to all the other discussion that was held? And that's really what this is about. This is about the fact, and in 2007, 2008 Good Government Guide, all it listed was what the ordinance said. It wasn't until 2008 and 2009 where the city attorney changed his opinion and added all this extra verbiage. And as a result, city bodies started to say, oh, let's just stick the comments of the public over here. And I'll guarantee you, if you think about it honestly, if it was a bunch of praise, they wouldn't be doing this. It's the disagreement that they don't like, and that's the one thing that the law, both the Brown Act and the Sunshine Ordinance, are really specifically set to determine. It is to ensure that political dissent is not squelched. And they want to stick these 150-word summaries somewhere else. Basically, I don't like having to do the 150-word summaries. I wish, honestly, I could go before the body and have them represent what I said accurately. But my experience over and over again has not. And I also know that most citizens in this city do not know their rights under the Sunshine Ordinance. And it takes someone like myself who wants to stand up and say, look, if you don't like the way you're being interpreted and represented in official records, you have the right under this ordinance, this added protection, where you can submit this statement and make sure what you really meant got in. And very frankly, I can show you 2 years or actually 3 years of documents where my 150-word summary and the summary that the Secretary of the Library Commission put in don't bear any resemblance whatsoever.
Thank you. Is there any member of the public that would like to offer?
Excuse me, no motion.
No, I'm sorry. Is there a motion on the, can I get a motion on the floor to find a violation of the Sunshine Ordinance? If there is one, Member Washburn?
I move to find violation of 67.16 for failure to include the summary statements in the body of the minutes.
I'll second.
City Attorney Threed?
Through the chair, may I suggest, in the interest of clarity, that the motion say include a phrase that it's at the point where the speaker made the comments.
Right.
A point in the agenda where the speaker made the comment. I think that's the intent.
Okay.
Yes, to be absolutely clear, yes.
So, Madam Clerk, can you read that back so we're all... Okay.
So Member Washburn, seconded by Oka, violation 6716, based on failure to include summary statement and body of minutes at point where speaker, point in agenda where speaker made comments.
Okay.
Minutes.
Thank you. Great. So you're... And once you get that, we can take a roll call vote. Thank you.
Public comment?
Oh, I'm sorry. Public comment on this? Is there any I can't see.
I'm tempted to say that in the spirit of Mr. St. Croix, I'm going to help myself to 6 minutes of public comment. That's my interpretation. But of course, that's meant as a joke. I think that members Highland and Sims are right on track. We're heading for anarchy as well as outright defiance of this body if we follow the logic that the respondent has provided. It's also discouraging because I'm Peter Warfield, Executive Director of Library Users Association. I'm not familiar with the details here, with all of the details, but I can certainly fill you in on some of the history, which is way, way more complex than what you may think. The Library Commission has reversed what people said so that their report was the opposite. For years, if you look at almost any Library Commission minutes, you'll find multiple members of the public, myself included, asking for specific corrections to the minutes which make us look bad, make us sound as though we said something that we didn't say or that's wrong, and on and on. Almost never is a single word changed at the Library Commission. And they've been experts at trashing and marginalizing the 150-word summaries in documents that were not included online with the minutes, where you had to either link to it or they simply weren't included. Having a long section of the signature of the secretary and then a long bunch of boilerplate so that you think the minutes are over when you've read them, and what is this stuff in the back? You wouldn't even get to it. Then they've had long, trashy claims, well, we don't guarantee the veracity or the honesty or the integrity of any of this crap that's following. They didn't use the word crap, but that was the implication. Do they guarantee the accuracy and the veracity, et cetera, of what they themselves describe, themselves as saying? No, they make mistakes. Do they guarantee the accuracy of their description of what I have said? And what I have said, if they report it, is there any guarantee of the accuracy? No. But they trash and marginalize other people's 150-word comments. Now, maybe next time you'll be talking about, how about if we put it in 4-point type? How about if we put it in upside down? How about if we put it in a lighter typeface? All of these are excuses and games to evade the clear intention of this amendment to the ordinance from 1999, Prop G. It's not indicated in the copy here. It shall be included in the minutes. It's your interpretation. This is important, and don't back down and let anarchy, anybody else's interpretation, rule. Thank you.
Is there any more public comment? If not, I'd like to take a roll call vote on the motion on the floor. Did you have something?
I just
I'm sorry, Member Nate
one
wanted to
brief
say
comment,
something.
Madam Chair. A couple of things. Yes, the charter is the supreme law of the land, of the city, and it does supersede the ordinance. But I don't see a conflict here between the charter and the ordinance with respect to what goes in the minute. Second thing I'd like to say is, we do have that history. The task force has that history of determining that summaries of people's comments should go in the minutes at the point where during the discussion those comments were made. And those votes have included the participation of voting member attorneys of the task force. The voting member attorneys of the task force are people such as David Snyder, most recently, who specialize in sunshine law. So they know whereof they speak. And again, the purpose of the minutes, as with any public record, is to make it as easy as possible for the public to find out what their government is doing.
Thank you. Madam Clerk?
Member Nee?
Aye.
Member Nee, aye. Member Monet?
Sorry, aye. Aye.
Member Monet, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Pilpel?
No.
Member Pilpel, no. Member Sims?
Aye.
Member Sims, aye. Member Highland?
Aye.
Member Highland, aye. Member Oka?
Aye.
Member Oka, aye. Member Fisher?
Aye.
Member Fisher, aye. Chair Grant?
No.
Chair Grant, no. You have 7 ayes and 2 noes.
Madam Chair, just very briefly, in my remarks, I was not in any way trying to minimize the contributions of the current voting member attorney we have on the task force.
Thank you. The motion passed. Madam Clerk, will you read the next item on the agenda, please?
Item number 7, file number 12050, complaint filed by Ray Hartz Jr. against Angela Cabello.
No. Yeah, what are we going to do with that? Well, the motion passed.
Right.
So they're in violation. Yes, we can. Yeah. Do you guys want to send this to?
So that would be to the call. That would be to the call of the chair as to where it goes from here. So the chair needs to determine whether this should go to compliance amendments or education, outreach, and training, or both, or none.
This has been at compliance before. I'd like to send this to compliance then, so I will make a note this will go to compliance. Is there any objection to this? Great. Madam Clerk, can you go to the next item, please?
Item number 7, file number 12050, complaint filed by Ray Hartz Jr. against Angela Cabello, clerk of the Board of Supervisors, for allegedly violating Sunshine Ordinance Section 6716, the minutes for the month of March through July 2012 and September 2012.
Right, I don't think, yes, there's, I can't see, okay. I don't think that they contesting jurisdiction, so is there a motion on the floor to, I'm sorry, I was tired. Find jurisdiction, a motion to find jurisdiction.
So move.
Do we have a
Seconded.
second? It's been moved and seconded, and I'd like to know if there's any public comment on this. If not, then I'd like to, okay, wait, you're stop. Okay. So I'd like to declare the motion passed without objection, and I'd like to call the complainant up to get your 5 minutes again. It's a long day.
And I appreciate Ms. Salisbury letting me know when I have 1 minute left. This is exactly the same case, and it involves the Board of Supervisors. And I would like to call your attention to the section 6716 in the minutes. And it is a earlier part of that sentence before the one we've been discussing in the last case. The roll call vote on each, it talks about all the things that are supposed to be included in the minutes. The time the board or commission began and ended a closed session, the names of members and the names and titles were applicable of any persons attending any closed sessions, a list of those members of the public who spoke on each matter if the speakers identified themselves, whether such speakers supported or opposed the matter, and a brief summary of each person's statement during the public comment period for each agenda item and the time the meeting was adjourned. The example that was provided by the clerk of the board is right here. Now, show me how that in any way meets the requirements of this section. James Chafee expressed concerns about the SF Public Library. Abdallah Magahard expressed various concerns. Ernestine Weiss expressed various concerns. Eugene Gordon Jr. expressed very concerned. Now, if you're a member of the public and you read that, what do you think? That they all got up and said the same thing? Talked about the same subject? Had the same opinion? Took the same position? And really, if you look at these minutes, this comes to the tension that has been between this idea of action minutes and whatever. Basically, the ordinance says that they're supposed to attempt to put in something there to explain what the person said. And this is what they consistently do every week at the Board of Supervisors meetings, is they put in nothing, or what they put in is meaningless. I had one case where I went before the Ethics Commission, and I talked about the fact that I had examined books and figures from the Library Commission and the relationship to the Friends of the San Francisco Public Library, and that I had found discrepancies and yada, yada, yada. And they were summarized it as Mr. Hart's discussed financial issues. Now, was that what I said? No. In fact, I got up the very next week and I made a 150-word summary and I said, boy, you really made me sound like an idiot. I got up just to tell you that I went through a bunch of financial records, but I did it apparently for no apparent reason, found nothing, discussed nothing, talked about it for nothing, just came here to jack my jaw. Bottom line is, this is the same issue. Do you, each of you, when you decide something is politically important to you, have the right to go to a public meeting, and if you disagree with that body or agree with that body, have a right to a reasonable representation of what you said, or can they simply say you talked about various items? And really, this is the ultimate. This is the basically, we don't like what people have to say. Now, I guarantee you, and I think you all know this, if every single person who got up and said, you're a bunch of wonderful people, greatest thing since sliced bread, you never do anything wrong, they probably wouldn't have any problem with any of this discussion we're having. But it's the people who get up who disagree with them. And the simple fact is, especially in my experience with the Library Commission, they don't like the fact that they get up and make statements, someone get up and disagrees with them, and it goes into the record, and they especially don't like it when you can point to that record a year later and say, I told you this at the time, so why are you now acting like nobody ever said anything? And that's exactly what they try to do. They want to keep dissenting opinion out, and it's something that the Brown Act specifically excludes. And I think the reason these 150-word summaries are critical is because it is an added protection to the protection of the Brown Act by allowing me and you, if you decide to speak, to ensure that what you honestly had to say makes it into the official record.
Hi, is there anyone here to offer any support or to introduce any new facts and evidence in support of Mr. Hartz in this case? If not, then I would like to ask the respondent to come up. You have 5 minutes.
Good evening, Rick Caldera, Legislative Deputy for the Board of Supervisors, and I'm not going to belabor the point after the last item. I just want to let you guys know that the Clerk of the Board really feels that she is indicating where the additional information is located. She puts it after her signature line, and she indicates there that, you know, his 150 words verbatim, the way that he presents them. She's not hiding them. They are in the minutes. I've heard several of you talk about in the body of the minutes. That's not what the code says. 6716 says in the minutes. You guys are adding the word body. It states in the minutes, when you click on the minutes open up. The 150 words is there. It says Board of Supervisors, it says meeting minutes, and it indicates where he spoke on the matter, where to find those in the minutes. That's really all I have to say, especially after the last item.
Thank you so much. Is there anyone here to offer any support or any new facts and evidence in support of the respondent? If not, then I would like to open it up to the task force members. If you have any questions for the complainant or the respondent. Member Washburn?
I have a question for Mr. Hartz.
Yes.
So for this particular matter, the complaint you're bringing to us, this is not about the 150 words. This is about...
No. I'm sorry. This is 150 words, and it was an additional point that I was making that there's an additional reason now for the 150 word summary, so that there's some accurate. There's something to represent what you said. Period.
Right. Okay. So you're not.
No, my same argument is the same case as the last one, which is 150-word summaries. This body has ruled multiple times, and the movement has been made. Bodies like the Library Commission, the Arts Commission, the Police Commission, and the Ethics Commission have started to include the statements there. And I have yet to have them identify one single problem with that simple change.
Okay, so I was a little confused. I look at I agree with your assessment of these summaries. They're not meaningful in any way, but that's not the matter for this complaint.
No.
This just shows that if someone comes forth with 150 words, it would certainly help anybody reading the minutes understand what they had to say. Okay.
Are there any more questions? Member Sims?
I guess the crux of the issue among us is that the 67.16 says that these are the items you have to include, and that you must include a brief summary of each person's statement during the comment period for each agenda item. Which, no one, I don't think, would argue that brief summary should not go where the agenda item is in the minutes. The next part that I guess is the argument that is being made is any person, speakers during the public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. It's really hard for me to not believe that last sentence doesn't refer back to that summary, which makes sense that it goes where it in that agenda item, because you have to look at the sentences as a whole. And I think if you look at 67.16 and it talks about the minutes, saying the time of the meeting call, the names and titles where applicable, any other persons attending any closed session, a list of those members of the public who spoke on each matter, if the speakers identified themselves, whether such speakers supported or opposed the matter, then it goes in about the brief summary. To say that the last part doesn't go, that means that they honestly could have put these people's names and all their summaries as well at the end of the minutes, not at that agenda item. And I don't think anyone believes that. I don't think you really can't believe that. I understand the clerk's interpretation, but as far as I think the task force interpretation is that it should go in the minutes where that agenda item occurred. Sorry if I didn't ask a question, more like give a comment.
Member Oka?
Excuse me. From what I see in what Mr. Hart's put up on the screen, he's referring to the agenda item public comment and not public comment on items discussed by the board during. So, public comment addressed this way makes no sense to me. And I believe the Board of Supervisors has to make better sense of the speaker's comments during public comment. This in no way tells me what everybody was speaking on. I don't even understand what people were speaking on in public comment here.
I'm sorry, we've done?
That's not really acceptable, I don't believe. So I think we need to clean this up.
Okay. So my question is then, Mr. Hart's complaint is that his 150-word summary that he provided is not in the body. So this doesn't have anything to do with this public comment. How the clerk or whoever took the notes interpret this. It doesn't offer a lot of what's really going on, but I think that's a separate issue. I do think that Mr. Hart's comments are not in the body, and that is what his concern is. So this right here, whatever we think about it, is not the matter at hand. What's at hand is where are Mr. Hart's comments. They are currently at the end of the minutes, and that's where the issue, and that's where the similarity with the case that we just heard. So, I mean, whatever our opinion on this is, I think that it's going back to the written summary that Mr. Hartz provides and how that is not included in the body of the minutes. And that's where, okay, so that's what I think we need to kind of focus on and kind of decide what we want to, whether we agree or disagree with it, whether it should be in the body or not, in our interpretation of whether it's in the minutes. And where it is now at the end after the signature is where people are disagreeing with, that's where the disagreement lies. So, Member Pilpel.
I think I'm clear with Mr. Hart's question to Mr. Caldera. I've made reference a couple of times to the charter provision about records being kept and the record of the actions. I'm not looking at that section right this moment, but do you think that charter provision bears at all on this question with respect to the board? Because the board has kind of, in my view, maybe slightly different requirements about record keeping. I don't know. That's why I'm just asking. Do you think that bears on the analysis?
As a master municipal clerk?
Yeah, for example, because,
we keep minutes the way that our bodies direct us to keep minutes. I mean, yes, we do have our own interpretations of how they should be kept. There is no requirements in the California Government Code section, considered the Brown Act, that states and stipulates how the minutes have to be written. The Board of Supervisors, different from this body, does have videos. This body has audios, and there is always, if somebody is not available to be here, as I've indicated to several of you in different ways, you guys have a requirement when you guys take your oath of office. One of the first requirement is that you attend meetings, and if you can't be here for those meetings, it's up to you to go back and figure out what happened at those meetings. I mean, you took that oath. You applied for these positions. As the clerk taking minutes for these meetings, though, pursuant to Robert's Rules of Order, there's no requirement that minutes even get approved. That's our record.
Okay,
that's the clerk's record.
I understand, but my question was specific to the charter requirement. Does that bear on this discussion, in your opinion?
This discussion really is about the 150 words. The clerk of the board indicates on which page Brayhart spoke and on which page that the 150 words could be found. So we're not hiding the
I understand.
words.
So what I'm hearing you saying is that no, the charter provision doesn't really.
This is about the 150 words pursuant to
understand.
6716.
Okay, so there's no conflict there.
I don't believe so.
Okay, all right, thanks.
DCA 3, I mean, you might have a differing opinion, but as far as no, I don't believe so.
Okay, thanks.
Member Oka?
Mr. Hart?
Yes.
When you click on your section of public comment, can you get to your summary?
Yes, if you go and you go down to the end of the minutes, it depends. It could be 40, 50 pages.
So it's not where you actually spoke.
Correct. And in other words, basically, I think it really comes down to the idea of in context or out of context. If you're reading a book and there's a footnote and you're the kind of person who wants to read the footnote because the author gives you some really interesting information about what's going on, you may go to that back page and look at the footnote. If you know that all you're going to see is a page reference, you may just skip over the footnote. And the importance is, if I read the minutes, which is the official record, I talked about recordings, audio recordings, and video recordings, and all that. If I read the minutes, there needs to be something to key me to go look at the 4-hour or 5-hour or 6-hour recording. And if there is nothing in there that in any way piques my attention, why would I go and look at the 6 hours? But if there's something in there like my statements and statements of others who've submitted these summaries, it may very well be the thing that gets somebody to say, I need to go look at page 624. But what I'm saying is, why should citizens have to be in that position of not knowing, especially when it makes absolutely, I have never heard one person in any of these cases get up and say, it's a real burden for us to put it in the body of the minutes as opposed to at the end of the minutes. They just simply continue to argue that, in the addendum, it's in the minutes, even though the city attorney's good government guide says the summary is not part of the body's official minutes. You can't have it both ways. You can't argue that it's in an addendum, it's part of the minutes, and then say, it's not part of the minutes. It's arguing one side, I can't even think of an analogy that makes any sense.
All right.
Any more questions or comments from the task force members? No? If not, then would like to ask the respondent if he would like to offer a rebuttal or any conclusion. Did he say no? Okay. I'd like to ask the same thing of Mr. Hartz.
Members of the task force, I would imagine all the city bodies and commissioners and whatever really do look at me as just being a pain in the rear. And they probably think I'm this old guy who has nothing better to do with his time than spend hours and hours and hours and hours and hours and hours and hours sitting and listening to city bodies. But the bottom line is, I have realized that many people in this city, in fact, I would have to say more than 99% of the people, don't know their rights under the Sunshine Ordinance. And I sit in these public meetings, I have my own rights abused, and I watch other people's rights being abused. And God has given me the ability and the will and the desire to do the research and present these cases and bring them forward for your consideration, not just for my own sake, but for the sake of every single participant. I have said this to many, many bodies at the first meeting I have ever attended. My two primary reasons for being here is, one, to ensure that every member of the public has an opportunity to have his or her words heard, and secondly, to ensure that every person has the right to access government documents, which they in most cases need to make credible statements. And really what we're talking about here is the fact that the citizens need to be protected. The government doesn't need protection against us. It's got hundreds of attorneys, whether it's the city attorney's office or anywhere else to defend the city. The citizens need to be defended, and their right to ensure that if they disagree with government, it's the First Amendment, not just free speech, but the right to petition government for redress of grievance, and that's what this is. If I feel you as a government body are doing something wrong, I have every right to come here and say, stop it. Or if you're not doing something, to start it. And the government, in most cases, is not going to like that, and they're going to want to marginalize it, and that's what these are all about. And it is each and every citizen. I am just lucky that I have the ability to recognize what is being done, and you know, we can argue about the result, about the reasoning and all this other stuff, but the bottom line is the result. If the result is my comments are omitted from the official record and the recordings and all that are not the official record, these are the official records. If they are admitted, my free speech has been abridged.
Thank you. So is there a motion to find a violation of the Sunshine Ordinance on case 12050?
Let Member Monet propose that motion. That's your last motion.
Thank you for putting me on the spotlight. I did find the first.
I'm still mad at you for that.
I filed the first motion. I actually defer to your judgment, Member Highland.
Please read the previous motion from the last case, the language of that one.
For item number 6, the motion was failure to include summary statement in violation 6716, failure to include summary statement in body at point in which the minutes were made by the speaker.
Speak into the microphone because she can't hear you.
Sorry, could you repeat that one more time? Sure. Could you repeat that one more time, please? Thanks.
Violation 6716, failure to include summary statement in body at point in minutes where speaker made comments.
So I'd like to propose that same motion for this case.
You think of to say it. I move that.
Seconded?
No. So you have to read it, say the whole motion because it's a separate case. Yeah. So I move that.
Let's see.
I move that the 150-word summary be put in the body of the.
I move that the summary from the previous, the motion from the previous case, the same language be used for this case.
No. Okay. Do I have a second?
I'll second.
And a third?
We seconded it at the same time. Great. But it can go to Member Oka.
Great. So it's been moved and seconded that there is a violation. Is there public comment on this? Let's see. Yes, no?
If you could let me know when there's a minute left, I'd appreciate it. Peter Warfield, Executive Director of Library Users Association. I'm not intimately familiar with this complaint as with the previous one, but with respect to the motion, I forgot to say something at the last one, but I will say it for this one and hope that you might go back to the last one, and that is make them fix it. These folks are violating the law, and I don't think it's good practice to let them off and say, well, as long as you don't kill any more people, in future, it's okay what you've done in the past, and you'll basically go off with a slap on the wrist. Make them fix it. There's a little thing called Word and other kinds of the magic of the computer. You just cut from here and paste it in there. Now, I'm glad we don't have the chair as our police chief or sheriff, because I imagine if there was a complaint that somebody saw a shot being fired at somebody, if she would send the police or the sheriff's folks there, she would tell them to ignore the other dead bodies that they happen to find. So I'm very much in favor of Mr. Member Oka and other folks, as this is a complaint about 67.16 being carried out properly. And the first two paragraphs of Mr. Hartz's complaint don't restrict the complaint to the 150-word summaries. I'd certainly like, now that you've noticed the outrageous lack of information in the minutes, I would recommend that you include that as something that needs to be fixed, or settle on a way to take it up as something to advise the supervisors on. I looked at one of the enclosed minutes, and on page 127, under public comment for what looks like Tuesday, September 11, 2012, 7 people out of 19 that I counted. Abdullah Megahead expressed various concerns. Male speaker expressed various concerns. Eugene Gordon Jr. expressed various concerns. Male speaker expressed various concerns. Douglas Yip expressed various concerns. Peter Warfield expressed various concerns. Ace Washington expressed various concerns. I don't think that satisfies the requirement of summarizing what the public said, nor do these that were shown before where a topic is mentioned. You haven't asked them why they have been putting up such a fight to continue to do this. Make them fix it. I want to add to something that Mr. Hart said. The Library Commission and others, I believe, also exclude positive things so that their story, oh, these people are a bunch of negative folks, can go forward. The whole practice of trashing public comment, as you've seen here, discourages the public, silences the public's visibility, and is a disservice to the public in general. Thank you.
Thank you. Is there any more public comment? If not, Madam Clerk, can we take a roll call vote on this motion on the floor right now?
Madam Chair, is there a referral on item number 7?
Can I amend the motion?
I'm sorry.
Can I amend the motion before we vote on it?
Yeah.
I wanted to add for them to correct these violations specifically listed in this case.
So what do you mean? You
To
want?
include the 150 words in these in the meetings that were referenced in this case.
But that's the same thing that was in the previous one.
Well, we didn't actually say that.
Because you just said to use the exact wording from the previous
Right,
one.
and I'm adding to it, and to also include the 150-word summaries that were provided at the time retroactively to make these minutes correct.
For those 2 meetings?
For the meetings referenced in this last case,
Okay, so for Mr. Hart's
second case, yes.
second case to
But
be...
I think we should also go back to the first one and include it in that too.
But that wasn't the complaint.
That's a separate.
Is that correct?
That's why I'm adding to my first complaint. Right.
Yeah.
That's a little...
So I can still add it to this agenda item.
That's what he's saying.
So you're just saying, okay.
Right.
Okay.
I'd like to add it to the previous one.
Got it. Okay. Understood. Got it. Okay.
And going forward.
Do you understand, Madam Clerk? Just so we're... I know, because she's not...
Can Member Helen please repeat?
Point of order. Chair might want to make sure that the second accepts the amendment.
Who was the second? Member Oka? Do you accept these
actually,
amendments?
I didn't quite understand what you wanted to include. Can you restate that?
Yes. 1 second. So what I'd like to add to the motion on the floor is for the Board of Supervisors to go back and correct the minutes of March through July 2012 and September 2012 to include any 150-word summaries that were not included in the body of the minutes at the point the speakers made their comments.
All right.
Do you accept it?
Yeah.
Okay.
Discussion.
I want to clarify one real quick thing, Member Pilpel.
I just want to clarify, is the request for those 7 specific dates or all meetings within those months? Because I wasn't clear on the way you stated it, and I think there should be as much clarity as possible here.
I think all meetings within those months referenced in the case and going forward.
Okay, just so that it's clear on the record.
The reason I made the statement that I made regarding making the Board of Supervisors clean up the whole section regarding public comment is that I want more detail on what was said during public comment, who said it, and this does not necessarily mean that if people added 150-word written comments, they should be, that goes without saying. What I want is more detail on what people actually said, and that should be stated in the minutes, because otherwise they're not real minutes.
Can we address that in this case?
No, that wasn't the complaint. So we'd have to, a member of the public would have to file a complaint about those issues. So, Member Washburn.
Or it's something that EOT could take up, too. That's also true. Yeah, something we could agendize.
Or whatever committee this matter is referred to the extent that it's related. But either way, yes, I agree.
Yeah. Yeah, that doesn't have to die with, no, we can take that up, certainly.
So do you want me to tell you where I'd like to refer it before we... I know I referred the last one to compliance, but I think that this is a bigger issue, so I would like to refer this to education, outreach, and training.
Nice try.
So can we take a roll call vote? Thank you.
Member Nee?
Aye.
Nee, aye. Member Monet?
Aye.
Monet, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No?
Pilpel, no. Member Sims?
Aye.
Member Sims, aye. Member Highland?
Aye.
Member Highland, aye. Member Oka?
Aye.
Member Oka, aye. Member Fisher?
Aye.
Member Fisher, aye. Chair Grant?
No.
Chair Grant, no. You have 7 ayes and 2 noes.
So this motion passed, and it will be heard at Education, Outreach, and Training. Thank you all for coming. Madam Clerk, can we go to the next item, the agenda?
Item number 8, approval of the May 2nd, 2012 regular meeting minutes.
So, Madam Clerk, I had asked people submitted their corrections to the minutes for May through March. And you have majority of them. I believe Member Pilpel has some here. Are these really long, intensive to go through each month, or?
I don't want to do that. There were a couple of things where I actually had a couple of questions. Do you want to?
Okay.
Can we
Why don't
spend a couple minutes on that?
Yes.
Okay.
But for the things that are like the...
Yeah, I'm not, no.
Okay, so
Yeah.
that, yeah.
I got through half of them. I didn't get through all of it, but I got
Okay.
through half of them, and I'm...
Thank you.
Thanks, Jerry. And so I would support adopting 5 of the 10, and I would like to continue going through this. I'm committed, or
Okay.
I should be committed.
So we'd like to
I think
approve
there's
5.
agreement on that last point.
Yes, I'd like to really...
Adopt the letter. Exactly.
Great, so let's go through them.
Wait
Do
a
you
minute.
have the copy? Can I have it?
Okay. With respect to the May minutes,
Oh,
I'm sorry. I just want to interject. So the minute edits that I did receive were from Member Nee and Member Washburn, so I have those here.
Okay. So you have their edits for...
This is May.
Oh, so you're doing it month by... Okay.
I'll do it month by month.
Perfect, okay.
And I was working off what you...
Gave.
Yeah.
Yeah.
Yeah, I got a set and I was working off of those, so.
Perfect,
it
okay.
was- The
So
system
this is
actually
just
kind of
May.
worked.
Great. But we want to do it.
No, that's what we have, which, no. this is-
Incorporating Member Washburn and Member Nee's corrections. And Member Pilpel is correcting currently.
It's got further
Yeah, so.
stuff.
He has a couple of questions. We're not going to go through the
Not everything in great
grammatical
detail.
stuff. Let's
No.
go through the content related.
Can we give
Member Sims.
it to two members of the public who are still here?
So if I may, on a couple of quick points.
For
May 2012.
2012, oh, yeah.
So on item 1, it was indicated that members Snyder, Cawthon, Manet, and Chan were noted absent, but at the top, members Snyder and Cawthon weren't listed, and throughout, members Snyder and Cawthon weren't listed. I believe at the time, members Snyder and Cawthon had not resigned and were still members, and therefore should be listed as members, should be listed as absent throughout, and that the total should add up to 10. Unless I'm wrong about the timing, I would just suggest that change be made throughout. Does that sound right?
Yeah, I wasn't here, so.
Yeah, I wasn't clear on that either. I had a note to myself, where are Snyder and Cawthon? Because I didn't think that they'd resigned yet either.
Right. Okay, so I think we're good with that.
So we'll just check that out.
Okay.
What was the other person's name?
Member Snyder and Cawthon.
Got it, okay.
I think, I don't think there's anything else that's substantive on the May minutes. Oh, page 7, sorry, at the bottom. So consistent with the action of the body earlier, do we want to move those two 150-word statements to where they should be? One of them is in the right place, and one of them is not so much in the right place. If the body chooses to move the comment on item number 2 up to where it would be under item number 2, I have no specific objection, and now would be the time to so direct.
Are you talking about the Supervisor of Records report?
Yeah, because that's, I mean,
Okay.
this is sort of like the addendum concept, but it wasn't exactly at the addendum point. It's sort of, is anyone?
Yeah,
Okay.
I would have agenda item number 2, public comment, be moved to
Number 2.
number 2.
So we'll just adopt what we have
Okay,
just
so it's that practice. So there wouldn't be no addendum. The 4 paragraphs that start with the italics at the bottom of 7 and the top of page 8 would be moved to the appropriate place under item 2, and the italic paragraph would be duplicated and left there for the item 23 public comment that starts at the top of page 8. Does that make sense?
Mm-hmm.
Okay. And then, okay, I think
Let's
that
just
works,
ask Madam
and I
Clerk.
will pass this over.
Does it work for you? Okay.
And if there are any concerns, we can talk through it, but I think the rest of it is
I just have one
non-substantive.
comment.
Yeah.
On page 8 at the top, it says that Member Nee was given a glass paperweight, but he's still here. So do you give that paperweight back, or do you?
Well, since the paperweight didn't come from the city, I see no reason to give it back, but
I hope you disclose that on your 700 form.
Okay, so
Perhaps he holds it in trust for a future, never mind.
Member Washburn?
Perhaps he uses it to throw it.
I just have one minor edit that I didn't send to you earlier. And that's item number 23, public comment, just a wording problem. We're talking about all the gift giving here. And Lars Nyman, this is the 5th line down in the public speakers. Lars Nyman spoke honoring for the SOTF, the members.
I got it. I fixed it.
Oh, you fixed it? Okay.
Where
All
is
right.
that?
Oh, I got it.
Page
Okay,
7
I
or
see it.
page 8?
So yes, so we
Just
have
the
that's in
wording.
your correction.
Okay, got that.
I got
Good.
I got all kinds of fun stuff.
Okay. All right, I'm cool then.
So you want a motion?
Yeah,
Motion
let's
in
just do
order?
it once. Let's
Okay,
just
so
keep
I
it
will
rolling.
so move to adopt with the latest and greatest with these corrections, and let's get it done.
Do I have a second?
Second.
Great. So the May 2nd, 2012 minutes.
Public comment.
There's no vote.
Public comment. We take public comment on minutes, right?
Public comment.
Yes.
Is there any public comment?
Yes, there is public comment. First of all, it seems that there's been a lot of action behind the scenes, which is unknown to the public as to what you're doing or what you're talking about. My version, which I believe Member Nee just handed to us, has exactly the error that Member Washburn spoke to correct, and which Member Pilpel said had already been corrected in apparently something that you have that I haven't seen.
He's correcting it.
Correcting it by
So what is it going to say? Do we know? Are we going to be told what it's going to say?
I didn't read all of those. That would take a long time. I can just tell you on that. The language I'm proposing would say Lars Nyman spoke honoring the SOTF members.
So I have spoken to the task force repeatedly over time, and particularly during the tenure of Ms. Alsbury, that the public is being inadequately represented in these minutes and under your leadership and membership. I don't think that the public is being fairly and properly summarized, and it's unfortunate that you have so many minutes to go through. On item 2, as an example, Paula Jessen presented the Supervisor of Records annual report. That's something that's prepared annually. That ought to be in the minutes. And it characterizes my comments as follows. Peter Warfield spoke expressing objection with the report.
I just had it done.
What did I object to? The color of the paper? There's no clue what the content was. Now, I happen to recall on that one that I believe I have had some very serious concerns with the Supervisor of Records, and one of those is that the Supervisor of Records is not following the time guidelines, the requirements under Sunshine. I'm sensitive to that because once in my life, once the first and last time, I thought I would get a quick resolution from the Supervisor of Records, and 8 days after dropping it off in person at the City Attorney's office, called to inquire what happened, they didn't even know they had it. It had gotten stuck somewhere. And then when I said, what about the 10-day, I was told, oh, we never meet the 10-day requirement. And the Supervisor of Records report had no indication of when the request for an interpretation had come in. That's my recollection. The key there was that their report omitted when the matter came before them, making it impossible for you or anybody else easily to see whether there was promptness in the response. And I think that in other respects, the public has been cheated, and you, by a weakness in the simple summarization of what the public has said. Thank you.
Thank you. Any more public comment? If not,
I added the word annual.
okay. So you will give that to Madam Clerk for May. Okay, so it's been moved and seconded to approve the May 2nd, 2012 meetings. Can we just take a show of hands, or is that possible?
Is there any objection?
Is there any objection?
Pass without objection.
Okay, I'm going to pass it without objection. The motion to approve the May 2nd, 2012 minutes has passed without objection. Let's go to June 6th. Can I get the Pass the copy around. This is for June?
Yes. So
Now I
item
just
number
have-
9,
you have a
approval
comment?
of minutes for June 6, 2012.
Great. Member Washburn?
Mr. Warfield raised an excellent point about our summaries of what the public has to say, and I think we, as a body, need to come up with some guidelines for ourselves as to what we require of our clerk to do in summarizing the public's comments. I don't want to hold up all of these minutes, though, because
I was going to discuss a rules meeting in April, and we can add that to the agenda, to the rules meeting. Is that what you're?
I guess that would be a place. I don't know.
I'm assuming that would be the place to determine that, and then from there, then take it to the body.
Yeah.
Yeah.
Ms. Osbury, so I'm taking over for a few minutes. So do I have to make a note of that? Do we make a note of that Member Sims is moving something to...
On record.
Okay, good. I take this seriously. Okay, where are we? Member Pilpel?
Okay. So let me, as others are looking through the latest and greatest version, let me just see what substantive things I had here. Perhaps not so much. Oh, on page 5, there was no recorded vote from Chair Grant, so we should probably find that. I was struggling on page 4 with the physically handicapped requirement. Perhaps we'll just leave that as the section 67.30A requirement, unless members feel strongly one way or the other.
I missed this. Where are you? What section?
Page 4 in the middle, there was considerable reference to the 67.30A requirement, or whether to call it, the physically handicapped. I'm kind of feeling, I don't know what I'm feeling about that. Are people okay with just referring to it as the 67.30A requirement? Yeah? Anybody care?
Yeah, I'm fine with 6738.
Okay.
In fact, I prefer it.
Okay. I like on the top of page 9 with the resistant, I think that's resistance CE. It wasn't intentional, but it was sort of cute. Never mind.
Is that
I fixed it.
18? Oh, okay.
Page 9 at the top.
Oh, sorry. Oh,
Anyway.
okay.
See, the problem is when you start reading the stuff you find funny. Yeah. Never
Yeah.
mind. Anyway, I think that's good. I also wanted to make clear throughout, this wasn't an issue with June, this was with some of the other sets. The boilerplate at the back, these 2 pages, were included in some of the sets of minutes. I believe that they are good and appropriate for the agenda and totally not required, and I would not include them in the minutes because I don't even think there's a dispute here that they are not required and aren't really part of the minutes. This is just stuff for the agenda. So it's not really an issue here, but I just wanted to say that. Otherwise, I'm good with June, and I will so move to adopt June with corrections.
Second.
Have any objection?
Public comment. We need public comment.
Oh, public comment first. Public comment? Anyone? You have 3 minutes.
Peter Warfield, Executive Director of Library Users Association. Thank you to Member Washburn for at least acknowledging a member of the public's comment in some fashion. I might let you know, in case you didn't already, having no
Sorry, Mr. Warfield.
I'm just getting caught up, so thank you. Go on.
Maybe I should start over again since you were not here when I started.
But she was taking care of it, so my vice
So
chair
now
was-
how many seconds have we wasted of my
You'll get
precious
yours-
3 minutes?
You'll get it at the end.
I thanked Member Washburn for making some acknowledgement of what I had said with regard to the paucity of, indeed, in the inadequacy of the summaries of public comments throughout much of the minutes. They are better than they have, in some cases, been in the past, but not, I think, good enough. And I had specifically requested that there be a little bit of a summary of what my issue was with the Supervisor of Public Records report. Not that I disapproved of it, but that I said I thought it should include and not be accepted until the date of each request from the public for an interpretation would be included as a routine matter so that you and others could see whether the promptness requirement of the ordinance is being fulfilled. And I was going to say in general that when you ignore the public, when you respond not at all to members of the public, it is not an encouragement to the public. If that's what you want to do, and that is to discourage the public, that's, just so you know, that's, as far as I'm concerned, my interpretation. On page 4, under item 4, there's a whole lot of people expressing concern with the task force being in violation of 67.30A, and it seems to be repeated without a lot of detail. And I think a little more detail could be provided rather than just a statement of a topic. I don't consider a topic statement a summary. On the bottom of page 8 under public comment, there were a lot of people at that meeting. It was an important meeting. And just as an example, Peter Warfield is described as follows, starting at the very bottom line. Peter Warfield questioned how the agenda was created. I don't even remember what that means in terms of what I might have said, and I said it. I have no clue what that means. I think you know me as articulate enough, and with whatever time was there, something was said about it, and it's incomprehensible from that entry. And I'm sure if you look and try and be fair to the public, I think you can and should do a lot better. In fact, generally speaking, I think that the task force should be exemplary in its actions, particularly in its treatment of the public. Thank you.
So what?
We have a motion on the floor.
Okay, for the minutes. You can continue, and I'll take it from there.
Can you reread the motion that we have? It's just to...
It was to just accept the minutes as corrected, June 6, 2012. Pilpel made the motion, seconded by Nee.
Okay.
Member Nee.
Can I assume we have that pass without objection?
Yes.
Okay, pass without objection. Thank you.
Madam Clerk?
Item number 10, approval of the July 11, 2012 special meeting minutes.
Great. So here, I'll pass them out. Oh, I'm sorry. Go ahead. Oh, is this all of them? Sorry. Let me give. Did I give you enough? I thought you wanted to. Let me pass. Thank you. Is this July still?
July 2, because remember there are two separate.
Oh, we had
Let's do one at a time.
Okay. Oh, yes.
Special meeting was first, right?
Yeah, they both were special meetings.
They're both
but-
special.
First?
Uh-huh.
Okay.
Here, I'm going to give it to you.
Let me
Here.
just,
Don't. On.
okay, with respect to the 4:30 meeting, I don't think I have anything of substance here. For example, on page 2, I've got Chemo Crossman expressed concern with the task force allegedly being in violation, instead of in violation of seriatim meetings, in violation of the seriatim meeting prohibition. I thought that reads better. I was trying to edit for content to make it a little more clear, to Mr. Warfield and anyone else who might be listening, if members of the public have specific suggestions for better verbiage, I'm certainly open to those sorts of things, and I would suggest that the task force is as well. I think we do want them to read well. So,
Madam Chair?
Member Nee?
Yeah, I got a couple things. In
Okay.
item number 2, this is of the first meeting, the
4:30?
4:30, yeah.
Mm-hmm.
Item number 2, the one of the speakers is identified as Mr. Clark without.
I got it.
Without a first name. Also, in item 10, the complainant's
Right here.
first name is misspelled. It should be Rob Burkhead, not Bob.
Oh, okay.
Yeah, I wasn't sure about that. It is Rob?
It is Rob.
Okay. That was in I think, the previous one as well. I'll catch that. Good. Good catch. Thank you.
Rob Burkhead. Okay. That's it for you?
That's all I had. Well,
Okay.
I had a few things, but I sent those in an email.
Yeah.
A bunch of syntactical things.
Okay. Anybody else have any other changes?
I would so move.
Do I get a second?
Second.
And as I said about the thing at the back.
Oh, yeah.
Yeah.
What did you say about that? I missed it.
To strike this.
Oh,
that
okay.
It's good for the agenda, not good for the minutes.
Great. Okay.
Okay.
And so, did you guys vote on that? What was
No,
that?
but I expressed that view, and I don't think there was any disagreement
Got
about
it,
that.
okay.
So I will move to adopt the 4:30
July.
minutes for July 11th with corrections.
And I believe there was a second today. Did you say, Member Washburn seconded that? Like to open it up for public comment?
Peter Warfield, Executive Director of Library Users Association. There is a mention here on item 1 at near the top of page 2. Again, in my case, Peter Warfield expressed concern with member Nee's outside counsel advice regarding 67.30A.
Oh, okay. There.
No clue what that means. I do recall there was a time when Member Nee requested that a question be answered by outside counsel, and there was a time when I expressed concern that this was being presented to the task force at a very late hour so that it was difficult or impossible for members of the public and other parties and so on to know about it. I don't know if that's what this is referring to. Following that, Dr. Derek Kerr expressed concern with the task force not being in with Section 67.30.
Nice, that's good. That's helpful.
I don't know what that means. And I would like to ask if anybody does. On page 3, under item 5, public comment, the summary for what I said could be interpreted to mean that I don't think people ought to have a right to have even 2 minutes, when it's very clear that I have insisted on a 3-minute time limit on at least 3 minutes for the public to speak. So what it says is Peter Warfield spoke in objection to 2-minute speaker time limit and in favor to the task force adhering to 67.30A. Well, the objection was to a 2-minute speaker time limit in contradiction to or in violation of the Sunshine Ordinance requiring at least 3 minutes. Somebody reading that might think, gee, this guy doesn't want any public comment. So that's all I have on that one, and I would ask you to correct these things, because otherwise they not only are uninformative, but they make members of the public look stupid and saying really the opposite of what they were saying. Thank you.
Can I get a motion to...
Have a motion.
Oh, we do have the motion? Okay. Can I say that this is so moved without objection for the first part of the July 11th minutes for the special meeting, the 4:30? Yes. So moved. So let's go to the second part of that the special meeting at 4:35. Where is, I don't have that.
It's essentially a one page.
Oh, maybe, okay, yeah.
It was just in.
I'll just follow yours, it's fine. Okay.
There you go.
Thank you. Are there any corrections?
They're very minor league. Public comment section, public comment, yeah. They're non-substantive. That was,
Okay.
It was our shortest meeting. It was.
Yeah, that was this, I remember that one. Okay. Anyone else have any changes or anything?
Also move to approve with corrections?
Can I get a second?
I'll second.
Second.
Great. It's been moved and seconded to approve the special meeting, 4:35, July 11th minutes. Is there public comment?
Well, I guess the chair has polished her ability to ignore the public and not even ask her own commission, her own body, whether they have any comment or any requests for changes. I think that's a very bad practice, and I think it's very unfortunate if the members of this body choose to completely ignore what the public is saying without even so much as saying, oh, I disagree. You're not obligated. There's no law requiring you to respond, but I don't think it's a good sign. I do think that members of the public ought to have a better representation with respect to the summaries of what they're saying. Peter Warfield spoke expressing concern with the late start of the meeting. Was the concern that it was not late enough? Was it concern with how late it was? Was there something else that he said? I don't think that that's clear from those comments either. And
Not sure what order.
as I said, I think it's unfortunate that the chair is once again having conversations on the side
I'm
rather
absolutely
than
listening to you and trying to take care of
and
work
talking
here,
with Member Pilpel or talking with Member Fisher at the same time.
Yeah, we're
it
trying to
doesn't
get stuff
look
clear.
like attention is being paid.
Mhm.
Thank you.
Thanks. Is there any more changes to this second special meeting at 4:35 to the minutes? If not, it's been moved and seconded. I would say this is passed without objection.
Madam Chair?
Yeah,
I just want
Renee.
to, I should have said this at the top, starting with item 8. Starting with, I should have said this earlier. Over the weekend,
Yes.
I went over those minutes very thoroughly, and I submitted reams of edits, and I hope they will be incorporated.
Mhm.
Not to items 8 through 16.
Okay. And I believe Madam Clerk has received those and is incorporating those into there. So
Thank you.
we've talked about it. So
Thank you. Thank you very
clear.
much.
Yes. And Member Washburn as well submitted edits. So she's very on that. Okay. So the second part, 4:35 for July 11th, those minutes have been passed without objection. So let's go to
Item 11, approval of November 7th, 2012 regular meeting minutes.
Thank you.
So move.
Second.
Here, I'm passing this slide.
With corrections, Member Nee?
Yes, specifically item number 12, again, the complainant's name should be Rob Burkhead, not Bob.
Yes.
What is that?
Thank you.
You got it? Okay.
Got it. So if I may? On the bottom of page 4, there wasn't a recorded vote of Member Sims.
Where?
The bottom of page 4. Probably in the nose, but
Okay.
we
The
should
motion failed?
find out. Yeah.
Okay.
I mean, history wants to know. History called me and asked, so never mind. On the top of page 3, line 4, I think length is better than lengthiness. I don't even know if lengthiness is a word, but never mind.
Where are you? Got it. Okay. The
It
length.
just seems like a long word, too.
Got it.
Okay, never mind.
I got it. We got
Yeah,
it.
okay, all right, sorry. On page 5, I think the attachments make sense on the agenda. It just looks weird in the minutes, in the italics for items 12, 13, 14. I mean,
So,
I
yeah, to
don't-
take it out of the minutes,
Oh, that's-
is what you're saying.
that's
Yes,
right.
that's an agenda. You're right. Yes.
on page 6, I think we should research on item 16. I suspect that I did not move to find jurisdiction since I voted against it, but we can check that somehow. I recall
Second it.
expressing concern about jurisdiction, so I think it's unlikely that,
Okay.
unless I did for purpose of discussion, but we can figure that out.
We'll go back and
Yeah.
listen to that and see about
Okay.
that. That's
I was
all
just
it.
concerned about that kind of record keeping, and
Yeah.
again, I cleaned up the thing a little bit.
Yeah.
Okay, I think those are the substantive things.
Great.
Thank you.
Is there any more comments from the task force? Any corrections? Any public comment?
Peter Warfield, Executive Director of Library Users Association. I guess this is the portion where you ignore the public and perhaps hope that we go away. These are not exemplary minutes. Items 4, 5, and 6, or 4 and 5, it appears that I said exactly the same thing on each one. Page 2, item 4, Peter Warfield expressed concern over the minutes not reflecting his concerns. Item 5, Peter Warfield expressed concern over the minutes not reflecting his concerns. This reminds me of the library one time who said that somebody discussed their opinion about something or another. That's not summarizing what somebody has said. Now, with respect to your own responsibility to yourselves as a body, providing useful minutes for yourselves, for your memory, for the record, as well as for the public, page 2, item 6, Sunshine Ordinance Task Force bylaws. I don't see here any mention of what this item represents. It bursts right in. Member Todd agreed with amendment. Member Washburn presented the reasoning of the former task force's rationale for amending the bylaw. And it goes on and on about amendments without saying what this is about. And the same for the public. Speakers, Patrick Monet-Shaw showed support of Mr. Grossman's presentation in opposition for the amendment to the bylaws. By the way, you've cheated the public out of Mr. Grossman's always excellent presentation by giving him not even a full line. Alan Grossman presented task force meeting quorum and voting rules. Peter Warfield expressed the amendment was a matter of justice for the public. Beats me. You know, when I'm talking, it's disconcerting when members of the body are talking to each other, and particularly the chair. Nine, public comment. Peter Warfield stated laws and rules regarding public comment time limits. Gee, what did I say about public comment time limits?
Speaker's time
There's
has
no
expired.
clue there, and I think it's a disservice to approve these minutes.
Do any of the other task force members have any corrections? Member Washburn.
Well, I think Mr. Warfield raises an important point about item number 6. You know, when I read over these, I know full well what that's about, but anybody else looking at these wouldn't know. And it's a very critical matter in the history of this body. It's it's the ostensible reason that the Board of Supervisors gave for getting rid of all of us. That wasn't really the real reason, we don't believe, but that's what they said. So I think that this should be, there's some explanation should be given as to the
expand
bylaws
on
were.
that.
Yeah, absolutely. And again, I think Mr. Warfield raises important points about summaries of members of the public and what they say. And I think going forward, I look forward to us coming up with some best practices for that. So, but I do think I would like to continue these minutes and have this fixed so that this important matter.
Item number
be-
6 particularly.
Yeah.
Was the bylaws, and we voted on changing the members.
Yeah, it was.
So,
It was a big deal. So it ought to. I mean,
I got it.
Cases are a big deal too, but this is kind of. Yeah, we don't know what it's about.
Okay. So,
Sure. I'm
Madam
sorry.
Clerk?
Yeah, through the chair. On that, item number 6 for the expansion, if you can provide me anything then you would like to add, that will be helpful also.
Yeah.
I can incorporate it.
Okay.
So, since there was a motion wasn't there a motion to accept these? So, I'd like
There
to.
is.
We need to amend it and see if we can continue it. Who made the original motion? I'm sorry.
Member Nee did on this.
Member Nee, would you move to amend it to continue this until we put the correct language in item number 6 to expand on that?
Yes, the chair will accept the amendment. I mean, I'm sorry.
I know.
The maker accepts the amendment.
Member Oka, will you accept this amendment?
Yes.
Great. So it's been moved in second to continue the November 7th, 2012 minutes. We'll move those to the next meeting, to the what is April? May meeting, to the May meeting. I think this has been moved without objection.
Sure, with the corrections, so they'll be the latest and greatest.
Exactly.
And if I might, just to Mr. Warfield, on the bottom of page 1, there's a note that items 3 through 5 were taken as a motion of the whole. That's why the public comment on item 3 through 5 are all duplicative.
Got it. Items 2 to 5. Okay.
So we did that without objection.
Well, no, we're going to continue the November 7th.
Continuing.
Yes, so we'll continue this one. And then, Madam Clerk, we can go to
Item number 12, approval of the December 5th, 2012 regular meeting minutes.
And Madam Chair, that's as far as I got, so I was going to move to continue 12 through 16 to the next meeting.
Good to me. Do I have a second to that?
Second?
But we got some work done. We really, you know.
Well, let's finish this one
Okay.
before.
Oh, I didn't get through.
Oh, you didn't do December
No, I didn't
5th?
do December. I got through
Oh,
November.
12 through 16.
Right. I got
1,
through
2,
half.
3, 4.
Got through half of them. I got through November.
1, 2, 3. Oh, I see what you're saying because there was 2.
There were 2 in
Got
July.
it for November,
Right.
for July. Okay. Okay.
All right.
So it's been moved and seconded. Is everyone okay with that? Because then,
Who made the motion? Sorry. Was that
who made the motion?
I did?
You did.
Okay.
And who seconded? Okay, Member Highland. So we've moved, it's been moved and seconded to continue minutes, items number 12 through 16. Well, actually, but you just made that. Okay, 12 through 16 to the May meeting so that we can incorporate
And I will try to
whatever
work
other
on stuff
changes.
in advance so that we, yes.
Yeah, exactly. So then we can get there. Is there public comment?
Peter Warfield, Executive Director of Library Users Association. First of all, I support the motion, and I appreciate that it seems to be motivated by a wish to do a fair and thorough job on the minutes. I heard Mr. Member Nee, say that he had submitted reams of edits. I believe for the July meeting. And I'm very troubled that this is a process that's not visible to the public. There's nothing in the room that indicates member requests for changes. And most particularly, I heard what I thought I heard was that the chair assured Member Nee that his changes would be made. Well, if you haven't discussed them openly in public and you haven't agreed to them in public, what is going on with this process? You're going to approve the minutes as one of your members who's been active on this is talking, and secretly, without discussion and without anybody seeing what these reams of edits are, those are going to be slipped into the minutes? I would certainly like openness from the Sunshine Ordinance Task Force with respect to everything, and certainly the minutes. So I'd like to ask, what is the process that you've been using with people submitting to somebody something about some of the minutes? I think you owe an explanation to the public, and I certainly think that any future minutes discussions should be open and clear as to who's proposing what and what exactly is being approved. So I'd like to ask, what is the process that has been going on here?
Well, what I've asked the members to do in order to alleviate some of the time here is that member Nee submits to our clerk, who's responsible for the minutes. Any of the members of this task force can submit their changes to the minutes to our clerk, who will then put those into her, edits. And then when we got these edits, that's when we vote on whether we want to approve these minutes. So I'm assuming that Member Nee is saying that all his edits aren't in there. Is that correct? Because, or Madam Clerk, have you gotten all of his edits and you incorporated those into these minutes that we are now approving?
I have received all of Member Nee's edits. Some were subjective, like express versus spoke. Those weren't included in there, but substantive ones, were included.
Okay. So that's the answer.
So you're saying the proposed changes by the various members that were sent to your administrator were included and are shown here today?
For those people that submitted them in advance to try to have something to present to our task force and the public. Member Pilpel, for example, did his edits today, and that is why we're going over them case by case, plus with whatever changes the public might have.
So maybe,
Which did incorporate some of your comments, Mr. Warfield.
thank you. I was going to ask about that because some of these things have had comments made previously, and it's completely unclear to me, as a member of the public who has commented, whether the public was considered at all with respect to prior comments. You know, these things get stale after a while, and when you come over and over again, it's not that easy to keep track of everything that you've said. I would appreciate if Mr. Nee would confirm what you've said, because I had the impression that something was going to be changed that hasn't yet been changed.
I have no comment.
Thank you.
You were good with this.
Madam
guy,
Chair.
right?
Member Nee?
Well, yeah, it's only under very extraordinary circumstances that members of the task force, including the chair, engage in dialogue with public speakers. Much as we value their input, and we have gotten some tremendously helpful comments from people like Mr. Warfield and Mr. Hart and Mr. Grossman and so forth, but for us to engage in dialogues, it's counterproductive.
Thank you. So we left off that we are going to continue the minutes, items 12 through 16. It was a motion second. It's passed without objection. Let's go to Madam Clerk, the next item on the agenda.
Item number 17, Report Compliance and Amendments Committee meeting, March 19, 2013.
I reviewed the minutes, our draft minutes from that meeting to jog my memory. A couple of the cases were not heard, the parties were not present. So we continued those at the call of the chair. There was one matter that we heard at some length, order of determination sent to us to see if the order had been complied with. This was William Clark against the controller. And we did not decide to bring it back to the task force. What we determined instead was that I guess the Arts Commission has been referred to the EOT for discussion and help with getting their record keeping in order. That's kind of the bottom line here. And they frankly have been so poor, the street artist program in particular, that it's frustrated members of the public trying to get information. And so that's what we determined. Well, you're hearing them on another matter, but that's kind of the part of the chronic problem here. There are other problems too, but that's something that the EOT can actually try to get a handle on and help.
We'll try to take a whack at it. Yeah.
Right, yeah. Good luck to you.
Great.
And that's it.
Thank you so much. Madam Clerk?
Item number 18, Administrator's Report. I think you should have the report in front of you.
Yes.
Okay. So it just outlines that first, that from February 28, 2013, March 27th, about approximately 198 calls, emails, office visits. Then you have before you the 2011 through 2013 complaint logs and communications received. Luckily, the good thing for mediation process is going very well. So we have 3 complaints that were resolved. And then the pending complaints are before you. We have 16 complaints in the pipeline. And that Anonymous has yielded some of her complaints that the chair had mentioned in the beginning of the meeting. And those complaints are before you. They are on number 5.
Great. Well, thank you. That's good. That's good. That's good to hear. For the administrator's report or for, okay. Member Pelpel?
Just a couple of quick questions. Thank you for making the complaint logs more readable by not having them be, shaded. On the 2013 log, can you just tell me under complainant what the asterisk at the end suggests?
That's in my own note. Which one are you looking at?
William Ledford and John Peacock.
Yeah.
Plan 3/3/2013. Oh, sorry. 3/3/2013 and 3. Yeah, both are 3/3. I'm sorry. 3/13/2013 and 3/3/2013.
I'm sure it means something. I'm just not sure what. That's all.
Okay, the complaint number though. What's the complaint number?
13010 and 13015. Just what was the meaning for the asterisk for those two?
No issue too small here.
Okay, 13010.
Yeah.
Oh, with this particular complainant, there's additional information she wanted to submit. So that's just a note to myself, and also with William Ledford.
Okay. So I think the important thing is item 5, that there are 16 live complaints that have not been resolved that are still in the pipeline. Jack? And that's totally helpful to have that bottom line number here.
Yeah,
Yay.
that was great.
And just the last thing, on the last page with the communications log, and I think I asked for this last month, can we also include the date of the communication just so that we can see in context, because there may be multiple things regarding immediate sunshine request from a...
That's a good idea. Do you see what he's saying?
The date or the date and the time, if we can just include that.
Is that easy?
No, that's a technical issue where IT is not able to extract the complaints. As these are coming from our emails, and for some reason it's not extracting the date. So it's something that I'll still work out with IT.
We're working on that.
Yeah.
Okay.
Just so I'm clear, so these 11 complaint from anonymous, which have been asked that we yield, I guess, action until further notice.
Yeah.
So is that included in the 16 or not included in the 16?
It is not included in the 16.
So we have 16
Plus her 11.
Plus her 11.
Right.
Okay.
So next time we'll try 7 or 8 or
whatever.
We'll figure it out. Just another question. If the communications log only includes email, were we to ever get something, I don't know, by fax or in paper, would that be tracked separately, or do we just now not get anything like that?
No, it would be included, but there have not. Most items or communications received are via email. I haven't received anything hard copy.
Okay, but if so, you'd either list it here or you'd list it somewhere.
Communications.
Everything would be there.
Okay, cool. Thank you.
And just so I'm clear, I mean, and this is maybe to you,
Kit.
Kit.
I know it's late. I know.
So the next meeting, will any anonymous complaints be on there at all, or will we start hopefully getting through that 16 complaint pipeline that we have kind of backlogged?
It's it's up. I can decide how. I've tried to go in the order.
Yeah.
But she has asked us to postpone until further notice.
Mm-hmm.
So the clerk and I will probably try to communicate with her and
Okay.
see if she's going to, so that we can get to those other ones and put
Yeah.
like 6 of the other ones on there. Right, Madam Clerk? Great.
Thank you.
Okay.
We're getting there.
Yeah, so we're really getting there. We're almost, we're going through some of these things. Okay, Madam Clerk. Oh, I'm sorry. Do you have anything else?
I'm good. Thank you.
Okay. Item number
19, announcements, comments, questions, and future agenda items.
Great. So
I would like to make public comment, which you did not
sorry.
call for this item.
Public comment?
There is a public present here, and the public has rights under sunshine in case you
Absolutely.
did not notice.
Absolutely.
Peter Warfield, Executive Director of Library Users Association. The first thing I wanted to say is that while Member Nee has an opinion about whether there should be so-called dialogue, I don't see that as a matter of principle there's any rule or requirement that you not respond to the public. There are sunshine. May I speak without interruption?
There is no interruption here.
Mr. Pilpel and you seem to be conferring.
We're not conferring, but you please go on.
The Sunshine Ordinance specifically states that you may respond to specific questions or refer people. I can't cite you chapter and verse at this moment, but there's only a prohibition about lengthy discussions that in essence are unagendized discussions and certainly actions. But I think that simple answers to simple questions or a referral to somebody who knows what's going on, perhaps your administrator, is entirely within the understanding of Sunshine, and I don't think that you should be leery of briefly responding when there is a specific question, such as a procedural question. I don't understand under item 5, the anonymous complainant has requested to yield all complaints, submit until further notice. Don't understand it. Does that mean they've dropped it? They have withdrawn? I don't get it. You can answer me afterwards if you like. I'm very concerned about mediation of complaints not being public enough with respect to exactly what the issue is, because I think members of the public and yourselves need to know what sorts of complaints, what sorts of problems, where the ordinance is giving difficulty to respondents or complainants. I'm also very concerned about what the process is and what goes on behind what seems to be closed doors and is apparently, for the most part or entirely, unreported. I wanted to ask you also, first of all, thank you for the referral letter of library users complaint number 12001 to the Ethics Commission on March 7th. Unfortunately, Library Users Association hasn't got a record of receiving a copy of this most important document from the Sunshine Task Force. And as a simple courtesy, it seems that that ought to be included. I can also say that this log lacks that update in its listing for the 12001. And I'd also ask you very sincerely to attend those meetings, because Mr. St. Croix has already distorted key thing like who was the complaint against. He said it's against Kate Patterson. She's just a frontline soldier who's been thrown into the fray. It was very clearly in your documentation, many times repeated, it was Library Users Association against the Arts Commission, not Kate Patterson. So I hope you'll make it a policy to have some representation at Ethics Commission meetings. Yes. Next one for 12001 being April 22nd. Thank you.
Thank you. We are on item number 19. Announcements, comments. My first announcement is I want to thank Suzanne Monet for my brief time here. You've been very helpful to me. We are going to definitely miss you. Thanks for all your support, all your guidance, and we wish you not to work too hard, and a lot of success and luck, and hope. Come on and sit in the public for public comment anytime.
It's certainly been my honor and pleasure to serve these 4 wonderful, rewarding years. I thank you all. And definitely, I'll be sure not to be a stranger.
Yes. Thank you. Thank you, thank you, thank you. The next item, Member Highland.
I just wanted everyone to look forward to the scheduled July 3rd meeting, which is the day before July 4th. And it seems like every time we bump up against a holiday, it gets changed. So why not be proactive on this? Perhaps if, I'm not sure who books our rooms. I don't know if it's the clerk.
Madam Clerk.
Madam Clerk can maybe be a little proactive on this and try and book us in on the Monday or the Tuesday if rooms are available, July 1st or 2nd, or even July 8th or 9th, rather than waiting a whole week. The reason I say that is I think a lot of us are trying to plan vacations between meetings, and this happens to be one of the months that has the most amount of time between meetings. Mm-hmm. However, if that goes forward a week, that will not be the case. So if we're proactive on this, and we can snag those rooms so to speak, ahead of time, that might be useful.
So yeah, if everyone could think about like their schedules and if they're going to be in town or what would work best, Member Highland was saying the week before, the week after, what days will or will not work, and let Madam Clerk know that, and then we can discuss it at the May meeting. I'll put that back on the agenda at the end. Say it again?
For action.
For action, for us to decide. So thank you, Member Highland, for that.
Thank you.
Question, Chair Grant?
Yes.
I mean, should we just aim for the 10th, which
I don't
is
know if
just
people
the next
need.
Wednesday?
That's what I'm trying to avoid.
He's trying to
We don't
figure
wanna
out.
go
You
that
wanna-
far?
Well, it just why not aim earlier? That's what I'm saying. Why not the week?
Well, because we have our June meeting. When's our June meeting? June. So it would be meeting twice.
June
So yeah, so we need to,
is
that's why I want to give everybody a little bit of
June
time to
5th.
figure out their
Let's
schedule.
bring some dates and
June
see what
5th.
sort of-
June
yeah.
5th.
The only reason I'm suggesting the 10th is because I have standing meetings on Mondays and Tuesdays with other organizations.
So it
So
won't
I was
work.
just trying to keep the Wednesday thing.
So
Like
that's
if
good.
it's
So that
Wednesday,
will work
it must
for
be
you.
sunshine.
Okay, so let's see. Let's just, everybody kind of give some dates and then we'll work it out.
Another option is June 26th, Wednesday, the week before.
Okay, so we'll see if that works
I
for
mean, it
people.
doesn't matter if we
people
have
want
two
to-
in June. We've got a lot of work to do.
Right.
Yeah, and also, you also have to remember that we have the committee meetings too, so you would be meeting 3 times that month.
That too.
So if that works for you, and for some of our schedules, it might or might not work. So let's see, and let's propose some dates and send them to Madam Clerk if that's okay, and come up with a date.
So you'd like us to email Madam Clerk directly?
Yeah, is that okay, Madam Clerk? So we'll just give you alternate dates, either the week before July 4th and the week after. And if it works more for the majority the week after, then we'll do that. If it works for that last Wednesday, because she has to see if she can get the rooms too. That's the other thing. And remember about the different committee meetings too. And that being said, just to let you guys know, Member Highland has agreed to serve on the Education, Outreach, and Training Committee. So we won't be at a loss with Member Monet. So
It'll definitely be a loss. It'll be very hard to fill
yeah,
her
we won't be
shoes.
at a loss.
I object. There will be.
You know, that's what I mean. So you'll have some help there.
Backfill rules, or is he on both?
Say it again.
Well, remember.
Yeah, he can still be on rules because that meets periodically, so we're good. And Member Pilpel?
Yeah, just one item in this section. I understand that the Supervisor of Records annual report for 11/12 is now in, and I'm hoping that we could schedule that for next month because we're a few months behind on that. Perhaps as the first item, which is how we normally handle that report.
Say it again.
The Supervisor of Records report that was referenced. We just, I believe we just recently got the report for 11/12, which,
we did?
which covered through the end of September of 12, and we're now months later. So if we could
have them and
perhaps
then
hear
come and
that
speak.
at
Okay.
the beginning of next month's meeting as
Let's
the first.
see where it fit. Yeah, we'll see where we can get it in the agenda.
Member
So we'll
Fisher,
make-
when are your Monday and Tuesday meetings? You said you had standing meetings on Mondays and Tuesdays. When do those
Tuesday
end?
is the first and second and fourth Tuesdays of every month. And my Mondays are the fourth Monday of every month and the second Monday of every month. And the reason I'm going backwards is I can miss the second Monday.
Okay, so it looks like July 1st is open for you.
Is that a Monday?
First Monday, yeah.
That works.
That's the thing, so, everybody's going to, that's why I was like, let's avoid this right now.
Add them up and see.
And see who the majority, yeah.
I think June 26th might be golden.
So we'll see. And then the room, we don't know, like, there's so many things, so.
June
Just
20
everyone
June
submit something to the clerk, and then
Not
we can
June
move forward.
26th.
Okay.
That's just before Pride
So,
weekend.
let's not try to figure this out right now.
Can't even wait. I could be afloat.
Let's try to figure this out. Okay, are there any more announcements? Anything else we need, you guys can think of for the next meeting?
And we are intending to have an EOT meeting this month. We're looking at Monday, the 29th.
Great news. I think, Madam Clerk, you have to see if the room's available, correct?
There's a room available.
Great, okay. So on that note, the EOT, it is
We're not sure yet. It's there was some confusion about that. I'm waiting to hear back from member David. In the 4 to 5:30 range. I'm trying to move it earlier so that we're within time and other, well,
So we're trying
we're
for.
trying to straddle that line.
I was just asking, is it at like 1 o'clock?
Are you in that
we're,
committee?
We're looking at somewhere in the,
No, but I like to learn.
Oh, okay.
we're looking in the 4 to 5:30 range.
Okay.
4-ish would make it more
That's
city-friendly, 5:30-ish makes it more public-friendly. So
Great. As
we
long
may
as it's
split
not
it
1
at 5.
o'clock is what I'm getting at. Those
That's
meetings
way
are-
too early, 'cause
Those are killer for me.
Okay. If there are no more comments from the task force, I'd like to open it up if there's public comment.
Peter Warfield, thank you for your concerns and for your suggestions. I'd like to chime in again with respect to Member Monet's service here and thank her. I'd also actually like to thank the holdovers and everybody, because all of you do a lot of work to be here. And whether we agree or disagree, I know that I sometimes speak sharply, but it's because I care about open government and democracy and people's rights in our system. And you guys are a very important, you play an extremely important role. I also appreciate Member Nee, and again, all of you, despite any differences you may have with the public, have to put a lot of work and a lot of time, much of it not visible to the public when they come to a meeting like this. But I guess we know that there's a lot of work that you've got to do, and I appreciate it. With respect to the Supervisor of Records report, I hope that you'll keep uppermost in your mind and perhaps request that it include the dates, because the promptness of that process is crucial to, if I may say it, luring people in so that they don't come here, but hope that the city attorney will give them a quick and decisive decision. And so the statutory requirement for promptness is something that you should insist they allow you to review by simply including the date that they got each one of the requests for a decision about the law. I'd also like to suggest what hasn't been said here, but I've said it over the years a number of times. I think you would benefit greatly if you would solicit the public in the broadest possible sense for what they think is working or not working with Sunshine, and what they perceive in the city as working and not working, whether or not you are the proper forum for remediation. I think that there's some background, there's some history that I think would be useful from known folks, but also from unknown folks. And in the broadest possible sense, soliciting the public, I think, would be a very worthwhile project for this body to undertake at some time, preferably soon in the future. Thank you.
Thank you. If there are no more comments, I'd like to move that we adjourn this meeting. Do you have a second? Without objection, this meeting is adjourned. Thank you so much. See you next month. Or sooner.
Oh, up here. Oh, up here.